16 tag method. Due to some personal difficulty, I could not go through the briefs yesterday night.
14, 15, and 16. When do you want?
After 2 weeks.
And inform the other side.
Yes, I have taken consent of the.
On a request made by Sri A.R. Tahvil, the learned counsel for the petitioner. Matters are adjourned to be listed when? Pleadings exchanged. Pleadings have been exchanged.
August,
Huh?
August 18, 19, any.
Will have it on 19th August?
19th August.
19th August.
Lordship, can it be on hearing day? Can it be on a hearing day?
Hearing day?
Yes, 18th.
Okay, then 18th of August?
18th, Lordship.
18th of August. At I order. Petitioner at I second at a petitioner.
Obliged.
Yes. 18 August.
May it please, Your Lordship. With the consent of the other side, I beg to mention item number 12, Your Lordship. In this matter, senior counsel Mr. B. Datta is appearing. Due to some personal difficulties, unable to appear.
Other side informed.
Yes, Your Lordship.
When do you want?
12th of August, Your Lordship.
Okay. On a request made on behalf of Sri B. Datta, learned senior counsel for the petitioner, matter is adjourned to be listed on 12/8.
Deeply obliged, Your Lordship.
May it please, Your Lordship. I'd like to mention item number 17, Your Lordship.
17.
17, my lords.
Yes.
Learned senior counsel R.B. Fukan is out of station. So the matter may be listed after 4 weeks of time. We have taken consent from the other side, my lords.
You have taken the consent.
My lords.
When do we have this? Pleadings are exchanged.
Pleadings are exchanged, notice is served, and matter is fixed for.
Don't have they filed the affidavit?
My lords,
You're not aware.
I'll have to check.
On a request made on behalf of Sri R.B. Fukan, learned senior counsel for the petitioner, matter is adjourned to be listed on, we'll have it on 27th, 26th of August.
My lords, September, anytime in September, my lords.
Okay, then 2nd of September,
May I please, Your Lordship?
29.
With the consent of the other side, I beg to mention item 10 in today's daily list. My lords, we have sent the affidavit for vetting.
Inform the other side.
Yes, my lords. We have made a telephonic communication.
Sri S. Sharma, learned counsel appearing for the APDCL, has informed that the affidavit in opposition has been prepared and sent for vetting, and he accordingly prays for some time. Para, in view of the above, matter is adjourned to be listed on 17th, by which time the affidavit, 17th, by which time, the affidavit in opposition is required to be filed. Yes.
For listing of an IA, Lordship.
Fresh matter, fresh IA.
Fresh IA.
When did you file?
Today morning. WPC was yesterday. Actually, after moving the WPC, we got to know that the tender has been extended up to 11th of August.
Okay, when do you want?
Tomorrow, Lordship.
Tomorrow.
Tomorrow.
When is the WPC fixed?
11th of September.
Then IA, how will it come tomorrow? When did you file today?
Today morning.
Okay, let us see tomorrow.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item 43, Lordship. Yesterday, we have circulated adjournment slip in this matter, Lordship. I've informed the other.
For the respondent.
Circulation of adjournment is not a right. It's only an information giving. Why do you need time?
Lordship, in this matter, we need some instruction from our client, Your Lordship.
22 matter,
Yes, Your Lordship. Just for 4 weeks time may be allowed. So that we
not
can-
4 weeks. 22 matter. We cannot afford to give 4 weeks. A prayer for adjournment has been made on behalf of the petitioner. Full stop. However, considering that the matter is a long pending one, this court has reluctantly acceded to the said request. Full stop. List. Matter accordingly stands adjourned to be listed on 18th of August.
Lordship, interim order date may be passed.
Interim order passed earlier to continue till the next date of listing.
Obliged.
Acceded to ACC, huh?
My lord, I beg to state, my lord, item number 6 and 7, my lord. I have to implement Jal Shakti as a party in Water Resource Department. Jal Shakti has not been made party, so I
Who has not been made a party?
Jal Union of India, my lord, not
Okay.
made party. So, my lord, in both the cases, my lord, I will file IA, my lord.
IA, okay. Your DK Jain,
Yes, ma'am.
okay, separately, huh? Sri DK Jain, learned counsel for the petitioner, has submitted that implement application is required to be filed for arraying appropriate parties as respondents, for which he prays for some time. Para, matter accordingly stands adjourned to be listed After 2 weeks,
Yes, ma'am.
by which time the implement, the DI, which may be filed, is also to be listed.
Item 6 and 7, madam.
Separate orders, huh? 6 and 7. Okay. Water resource, you have informed water resource.
I will inform, madam.
Oh, I will not do, Mr. Jain. What is this kind of practice? Again, we have to repeat every day.
I will take over telephone, I will inform, madam.
Not, will not do. You be on the other side. We'll make you wait till 4:30 without information. What is this kind of practice? I will inform.
Let the matter come, madam, then.
Please have the basic courtesy of informing advance in the earlier evening.
Sorry, madam,
Yes. Inform and come. Thank you for the idea. No.
My lord, this matter may be listed for admission, my lord.
Admission, which matter, which year?
My lord, this 2024, my lord, it was last listed on 30th.
What is the urgency? What is the subject matter?
Surgery, non-payment of contractors dues, my
Sorry.
lord. Regarding. My lord,
Sorry.
this matter only once listed, thereafter it has not been listed, my lord. Any day, my lord. Next.
Once listed, after notice, it has not been listed. Okay, then Monday.
Monday.
My lord, we are for listing of the matter for withdrawal, my lord, on Monday.
and I will inform the.
Okay, thank you. Date दिलो नहीं कि बार? 2 weeks, so take it. Along with the IA, take it. Yes, madam.
May I please, Lordship, item number 13, Lordship, I'm under prayer to withdraw this matter, Lordship. Matter pertains to non-payment of contractual bill. The financial dues has been paid to the petitioner, Lordship.
Okay. What is your name? Asdole.
Hey, fine.
A. Payang. Miss A. Payang, learned counsel for the petitioner, has submitted that though the grievance of the petitioner was relating to non-release of contractual bills, comma, after filing of the writ petition, comma, the bills have been cleared. Full stop. She accordingly submits that she would not like to press the writ petition any further. Pala. Also heard Sri R. Talukdar, learned state counsel. Sri Satyajit Datta, learned standing counsel revenue. So finance, anyone finance? Sri M. Bhuya, representing the finance department. Water resource? Water resource, who normally appears water resource? And Sri, is he there in the court? And Sri RM Das, standing counsel, water resource department. Para? Writ petition is accordingly closed as not pressed.
Okay, Lordship.
Need please, Lord. As regard item 3 and 4.
Yes.
In fact, your lordship has been pleased to accommodate on many occasions, Lord. But today we are both on the same other side, Lord, in another case, Lord. But I was praying for a next second half, Lord. My friend has some difficulty second half.
3 and 4.
Yes,
When do you want? 22 matters, 18 matters, my God.
I understand, Lord.
On 12th or 14th of August.
We are not adjourning. Sorry,
I'm
Or then, Lord, kindly take it up at 2 o'clock, Malad.
we will not know.
Little accommodation.
We are not adjourning. 18 matter, no adjournment.
My lord, in that case, I want to assess this honorable court because there are many decisions.
You do
of-
whatever you want when the matter is called upon. We'll hear the matter and pass final orders.
May it please, your lordship. Lordship, item numbers starting from 28. Those items, those review items contains, there was understanding in the last occasion that we need.
Yes, yes, yes.
That may be taken up. Can it be taken up?
We have a few, I think,
Total 19 items are there.
we have 1 or 2 motions, I think.
After the motion?
No, there is one part heard also, that Mr. Jyotirmoy Roy's matter. Item number 45. This is a part heard matter. We'll have that first, then we'll have your series, okay?
Oblige.
We'll have the motion, then item number 45. Please inform 45. It's part heard.
May I please, Lordship?
J. Roy and other side, I think Mr. Chakraborty, B. Chakraborty. Yes,
Please, Lordship. Lordship, I beg to mention the list the matter for miss case. Lordship, we file miss case, we list the matter for admission.
admission. When did you file?
Lordship, it's file,
Has it come earlier?
yes, Lordship.
Has the IA come earlier?
No, Lordship,
Not listed.
not listed.
We'll have it on Monday then. IA for what?
This case was dismissed for default of.
Restoration application.
Yes,
Okay, then Wednesday next. It has to be traced out. Wednesday next.
Mondays.
এইটো খবৰ দিবা দেই, এইটো পাৰ্থ হৈ আচলতে নিৰ্মল দাসটো পাৰ্থ লিখা নাই। এই যে কিবা জে ৰয় আছিল আৰু এইফালে বি চক্ৰৱৰ্তী আছিল। Yes, Mr.
Your Lordship, my lord, Singia bi-weekly market in the district of Nagaon has been settled with 31-man committee in violation of Panchayat Act section 105. So the committee is collecting tolls from through these 31 persons after taking ₹10,000 from each of the members. So our demand is that the bazaar should be settled through tender process.
Yes,
And
what is this?
in this regard, my lord, your lordship has an order. We have annexed that order. Kindly see page 31. So we also expect similar order.
31.
Yes.
Yes,
Communicated to the government for regarding the tender process, Lordship.
microphone.
We have communicated to the government, Lordship, regarding the tender process. The same is still pending.
But you, there will be violation of 105 and 47 rules, isn't it? Heard Sri M.U. Mahmood, learned counsel for the petitioner. As per the facts projected, the petitioner is the earlier lessee of the Singia bi-weekly market in the district of Nagaon for the year 2025-26. Full stop. However, after completion of the tenure, instead of initiating a fresh tender process, the market has been allowed to be run by a 31-member committee, which is in violation of the statutory prescription.
Well,
Full stop. The learned counsel has submitted that in matters of distribution of state largesse, there has to be transparency and fairness.
yes.
And by the present arrangement, the rights of the petitioner, who is an intending bidder, has been adversely affected.
Yes.
Let notice be issued. Returnable on.
But may I expect it to be disposed of similar order? Madam?
Those are not
Otherwise-
disposed of. Those have not been disposed of.
But earlier was,
It was, the notice has been issued.
but that order, I mean, this similar order, by that, when it is produced, then the bazaar is settled through tender process. In that case.
That will do.
So exactly similar order is passed.
Let notice be issued returnable on today is 6th. On the 7th of September 2026, Ms. P. Thapa, learned counsel, appearing on instruction of Sri S. Datta, learned standing counsel PNRD, accepts notice on behalf of Restaurant 1, 3, 4, 5. Whereas Sri R. Talukdar, learned state counsel, accepts notice on behalf of respondent number 2. Extra copies, last steps be taken 6 by speed post with AD. Steps within 2 days. Sri Mahmood, the learned counsel, prays for an interim order and has submitted that in similar matters, this court has passed interim orders. Considering the facts and circumstances,
Further extension of time to the
it is-
31-member
it
committee.
is provided that the interim arrangement made for running the market by the 31-man committee shall remain suspended. Full stop. The market, the department shall take appropriate, take expeditious steps for settling the market in accordance with law. Until such time, the market would be run by the department on its own.
Right, highly obliged.
Lordship, kindly pass over for the timing, Lordship.
You get the other side also. We don't want to have this matter pending.
Obliged, Lordship.
We have heard this. এটা একটু পাঠাট বলে লিখা নাই বা বলছি না the matter was heard in part on 2018-7 however due to paucity of time series to করলে আর একটু না হবে এটা হলো হবে যেটা হ্যাঁ সিরিজ তো ওটা করব লাগিব সিরিজ তো না হয়ে যাবে সিরিজ তো মনে নাই নাকি yes that series matter review নোট আছে নাকি এটাতে নোট এটাতে আছে না আছে না এটা আছে নাই না এটাতে আছে রিভিউ আছে এটা আছে মাটার কিছু yes where is Mr. Khatonier
I may be allowed to call.
please call Mr. Khatonier and as well as Mr. Mohanto. Where is this one? আছে না fully depend Madam, where is Mr. Mohanto?
It's coming.
Oh.
Yes.
Yes. So our basic ground was that, there was an observation in paragraph 3 and 5 that they have acquired the educational qualification prior to initiation of the recruitment process. And in paragraph 14, my lord, no.
What was your basic ground?
Our basic ground was that, my lord, paragraph 3 and paragraph 5 that they have acquired the qualification in from their advertisement made in the petition. They have acquired the qualification prior to issuance of the advertisement, my lord. The observation made by this honorable court was not. However, it is also a fact that even before the advertisement dated 11/3/2018 was issued, all the petitioners were possessing TET and DLED qualification. It appears that due to non-fulfillment of aforesaid criteria of TET, DLED, the candidate of the petitioner were rejected. So in fact, in their pleadings also, my lord, they have mentioned that they have acquired the qualification prior to issuance of the advertisement,
Yes.
which was not correct, my lord. So in paragraph 14
Of your review petition or the judgment?
Judgment, page 162. 162. This is review petition number 121, my lord.
Yes.
160.
Paragraph 14.
14. In this bunch of writ petition, it is not the case of the respondents that the petitioner do not possess the requisite qualification of TET, DLED, and the objection is only with regard to the date when such qualification of TET, DLED was acquired. As per the advertisement, the aforesaid qualification was required to be procured within a particular age. However, due to non-holding of the examination, such degree was not able to be attained within the prescribed age limit. However, there is no dispute that the such qualification have been obtained starting of the recruitment process. So that observation is incorrect, my lord. Accordingly, this court finds force in the argument made on behalf of the petitioner that by virtue of TET, DLED qualification acquired later, the same would relate back, and therefore the condition requiring that all qualifications should be attained within a particular age are duly met by all the petitioners. So we are basically agreed by this observation, my lord. That is
But
not
the
correct.
recruitment was started subsequently. The initial advertisement was done, but the actual recruitment started subsequently.
Subsequently, my lord, because after the High Court judgment, my lord, there's another notice, my lord,
Yes.
and after that, my lord, we have prescribed a particular age limit.
Yes.
Our second limb of argument that, my lord, that prescribed age limit that has already been they have crossed that age, my lord. These petitioners, they have crossed the age of 38 years when the recruitment process has begun, my lord. That is our second limb of argument, my lord. And that issue has not been brought before your lordship, my lord, while adjudicating the dispute.
That was that will not come with the ambit of review. It's not a new fact which after due diligence you could not know.
It was there, my lord.
It was there.
Since it's a bunch of repetition, altogether, my lord.
No, see,
30
new
or 40
facts which after due diligence could not have been detected. Now, you did not have the due diligence. Age was before you.
Yes, but that facts were before us, my lord, but it could not be brought at the time of hearing, my lord. Because only one issue was decided, and while deciding that issue, other facts could not be brought before your honorable court, my lord.
Second rule will not be a ground at all.
That is our second argument, my lord. And lastly, my lord, there is an observation by the honorable court on paragraph 17. 17, where my lord dealt with that acquiring of qualification. This court has also viewed the controversy in question both from the angle of public interest as well as efficiency in public service. Though the rejection of the candidature of the petitioners appears to be on the ground of not acquiring TAT DLED qualification within a particular age, it is an admitted fact that all the petitioners have acquired the qualification prior to the initiation of the recruitment process. When such qualification was possessed by the petitioners even before the recruitment process was notified, whether the said qualification was obtained within a particular age limit is wholly immaterial. In any case, such requirement having been removed by the clarificatory notification dated so and so published during the pendency of the petition, the rejection of the candidature of the petitioners appears to be done on wholly flimsy and unsustainable ground. And paragraph 18, my lord, the direction. On the backdrop of the aforesaid discussion, this court is of the opinion that the petitioners have been able to make out a case of interference in exercise of powers under Article 226 of the Constitution of India. It is accordingly held that the TET DLED qualification acquired by the petitioners prior to the recruitment process has to be construed to be meeting the eligibility criteria, and therefore, while the rejection of the petitioner in the recruitment process is set aside, the case of the petitioners for appointment of as assistant teacher as per advertisement so and so shall be duly considered, and based upon their position in the merit list, appointment be offered explicitly, and in any case within an outer limit of 45 days. So since there is a mandamus, now we cannot consider whether they are eligible at the time of submission of the application, whether they have met all the requisite qualification and eligibility criteria. That now we are unable to consider, my lord, because there is a mandamus to appoint the petitioners, my lord. Even assuming that, my lord, they have acquired the qualification prior to initiation of the recruitment process, but due to their fact that they have already crossed the upper age limit, they are not, otherwise they are not eligible. But since that observation is not in the order, my lord, now we are unable to consider their application on that basis, my lord.
We don't think these are matters grounds of review at all. Nonetheless, we'll consider since you have come. That's all.
That's all. I am relying on the judgment, my lord.
Please.
Pass by the full bench of this honorable court, my lord.
Which one?
My lord was also
That education matter.
education matter, my lord. 6 Shiksha Sarati, madam.
Yes. We have all discussed all the Supreme Court.
Yes, madam.
here.
That is why, madam, I am relying only this judgment, madam, because all the
Which
Supreme Court-
paragraph?
Paragraph 12 onwards, madam.
I think this court had given a concurring finding here.
Yes, yes, madam. Paragraph 32.
Thirty.
32, madam, concurrent finding.
Yes. Madhusudan.
Yes, it
Thirty.
starts from to paragraph 24.
Yes.
The concurrent.
And which paragraph are you?
I am relying from paragraph 12 onwards, my lord, where all the Supreme Court judgments were discussed, my lord.
It's okay.
Then, my lord, paragraph 19,
12, 19,
20, and 21, my lord.
20 and 21. Let us say 12.
No, I'm saying more directly,
These are the powers of the writ court,
Yes, my lord.
plenary in nature.
Yes, my lord.
There is no dispute to the fact that regarding the powers to be exercised for review. So
While I am relying, my lord, because, my lord, since
powers is there, you have to make out a case of review.
because, my lord,
But it is also the principle laid down that though per se the CPC is not applicable, but the spirits should be applicable.
Yes.
So spirits, what are the three principles? In broadly, we have to follow the three principles. Error apparent on the face of the record, discovery of new facts which was not brought to your knowledge in spite of due diligence. Third is sufficient reasons. Sufficient reasons has also been
sufficiency
explained.
on the ground, my lord, I am saying, my lord, that though that facts is already before this honorable court regarding the age of some petitioners, but that could not be brought because
That is not sufficient reason. That is due diligence. New facts which was not within your knowledge in spite of due diligence. This is not
those facts are otherwise in our knowledge because it is a pleaded case of the petitioner. But because all cases are clubbed
no,
together,
that cannot be a reason.
so my lord, may I plead, my lord, that only one observation that if someone is overaged during the time of initiation recruitment process, their case we may consider their case according to the eligibility criteria prescribed in the advertisement, my lord. Only that advertisement will,
That will be difficult.
because, my lord, direction was to appoint all the petitioners, my lord. Since in the present review petition, my lord, 121, all the petitioners, they were overaged, my lord, at that time.
What is the observation you are playing for? You are praying for?
I am praying for that, my lord, since some of the petitioners were already overaged when the subsequent recruitment notice dated 23/1/2020 was issued. So we can 23/1/2020, the subsequent notice, my lord. Page 132. Since they were overaged, my lord, so while considering their case, we can look into it, my lord, whether they are within the age limit or not, my lord.
Okay.
That's my submission, my lord.
Thank you. Yes. Yes.
No, my lord. Petitions, my lord, the grounds, whichever they have pleaded, my lord, they are not ground for review, my lord.
Hmm?
Only to delay the, my lord, the contempt proceeding, my lord. RFC shall file down. And regarding my lord, the upper age part, my lord. There was a notification of 29th October 2018, my lord.
Just a minute. Mr. Laskar, you are from in which matter?
My lord, in item number
Same matter, my lord, 121.
131.
Okay. J. Laskar.
Fine.
Yes, what are your submissions?
My lord, paragraph 14, my lord, already on last occasion, my lord, I have on your lordship.
Paragraph
Page
14 of the
162
judge,
of the
of
judgment.
the judgment.
My lord.
Yes, what is there?
My lord, in this bunch of writ petition, it is not the case that respondent that the petitioners do not possess the requisite qualification of TA, DLED, and the objection is only with regard to the date when such qualification of date DLED was required. As per the advertisement, the aforesaid qualification was required to be procured within a particular age. However, due to non-holding of examination, such degree was not able to be attained within prescribed age limit. However, there is no dispute that such qualification has been obtained starting of the recruitment process. Accordingly, this court finds force in the argument made on behalf of the petitioner that by virtue of the DLED qualification acquired later, the same would date back, and therefore the condition required that all qualifications should be attained within a particular age are duly met by all the petitioners. Well, after considering all this aspect, my lord, applying your mind, lordship, pass the judgment, my lord. And apart from this, my lord, this paragraph itself clear everything, my lord. So I don't think that this is a case for review, my lord. Regarding age relaxation part, my lord, there are all, this is an advertisement of 2018, my lord. During that period, 29th October 2018, there is a notification whereby the upper age limit was revised up to 44 years, my lord. And this is advertisement percent to 2018, my lord. And this is 2020, it's continuation of that advertisement, my lord. And all these things are before your lordship. That's why, my lord, paragraph 14 was ordered.
Anything? You are in the contempt. Contempt we are not hearing now. We'll
Just one point on regarding what my colleague friend has said regarding the vacancies that has already been looked into. Lordship will kindly mark judgment para 10(1) subclause 1.
para 10 at
Para
page
10, yes, page 116.
116.
116. Judgment para 10 subclause 4.
You can't believe it. Yeah,
160 or 160. I'm sorry.
160.
160. The last point 4. The availability of vacancies to accommodate the petitioners. Was founded. Recorded by this court in the order it is so and so. Passing when it has been recorded that so far LP schools are concerned, so and so post are vacant. So lordship, this order has already attained finality. There's an interim order by way of which the post were reserved and we have been asked to apply. And by way of that, the verification list was published and number of selected candidates are already published. They have not gone, the state has not gone and selected on list. So ultimately here, taking this plea of that overage thing will not come. Because by way of interim order, this has already been passed, a select list has been prepared, and ultimately it will not be contemplated because of this content, because of this review. So that is the current position in motion. They've already published the list, taking into account the merit positions as per the order of this court. So going back again will not suffice.
Okay. Mr. Laskar, anything?
I mean, item number 36.
Full Oscar. You are
Mine.
full Oscar.
My lord.
Item number,
36.
the number,
Item number 36.
case number.
Case number 4 of 2024.
Review petition.
Review petition,
Review 4 of
2024.
24.
My lord.
Okay. We have for the writ petitioners.
Yes, my lord.
What are your submissions?
The grounds taken by the state is, my lord, that the petitioners were not qualified at the time of advertisement. However, this has been taken care of in the document in paragraph 9 and as well as paragraph 14. These issues have been raised there, and your lordships have adequately dealt with all the objections. Another ground was that the notifications corrigendum that dated 22/2/2021 and as well as other notifications relaxing the age were issued later on the subsequently to the publication of the advertisement. That issue has also been raised during the hearing of the writ petitions. And your lordship has rejected that issue with reasons. So there is no ground for review. That is my brief submission. There is no ground for review as such.
Okay. Continue. Part 3.
But as regards their contention that it is a continuous process, that initial advertisement was issued in the year 2018 and it's a continuation in 2020. In that regard, my lord, my submission is that, my lord, at the time of initial advertisement, my lord, they are not qualified. They have not applied, my lord. They have applied after 23/1/2020, my lord. So that, during that time, they were not qualified. So they did not respond to that advertisement, my lord. They have responded to the advertisement issued on 23/1/2020, my lord. So the upper age limit prescribed in that advertisement is not applicable in the case of the writ petitioner, my lord, because in the 2020 notice, the upper age limit was 38 years, not 44.
But there was a clarification increasing the age.
That no, my
That
lord,
notification
my lord,
of
kindly come to
increasing the age.
page 132, my lord.
That those we have considered, we have already argued.
Yes.
We'll take into consideration. Yes. You are there? Yes. Item number?
Petition number 16 of it.
Just a minute, please. 16 of 2024. 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 Item number 30.
30, I think.
Mr. Bora, you are in, what is your number? Review number?
Review number 16, Lordship.
38.
16.
38 is 16.
16.
Yes.
And let me come to page 86, Lordship, paragraph 17, Lordship, of the review petition.
86 of 121. We are taking 121 only.
Lordship, review petition number 16.
Same judgment, or is it? Judgment, if you can give the internal page of the judgment. Is there any internal page of the judgment? On the top right, internal pages are there. Are you referring to the judgment?
Yes, Lordship.
Top right, internal page, give us the internal page. Top right,
Yes, Lordship.
just give the page number, we'll say.
To be internal page 4, Lordship.
Page 4.
WPC number 1016.
Are you referring to the judgment which has been, review has been paid for?
Yes, Lordship.
Give the internal page.
408.
There are narration of the all the case numbers from pages 1 to 10. It starts at page 10. On top right, there are the pages. Kindly top right,
4 of 18, Lordship.
page 4.
Yes.
Those are the names of the cases. Huh?
Page 16, Lordship.
Page 16, tell us. 16. Paragraph?
14, Lord.
Yes. And
In the
163.
count of the petition, it is not the case of the respondents that the petitioners do not possess the requisite qualification of that DLA, Lordship. And the objection is only with regard to the date when such qualification of that oblique DLA was acquired. Lordship. As per advertisement, the aforesaid qualification was required to be procured within a particular age. However, due to non-holding of examination, such degree was not able to be attained within the prescribed age limit. However, there is no dispute that such qualification has been obtained starting of the recruitment process. Accordingly, this court finds force in argument made on behalf of the petitioners that by virtue of date of DLA qualification acquired later, the same would relate back, and therefore the condition requiring that all qualifications should be attained within a particular age are duly made by the petitioners. Now, Lordship, may come to.
This has been placed by your learned colleagues.
Yes, Lordship.
That we have taken into consideration. We'll look into it. Mr. Khatanier is trying to build up some points. We'll consider that. Let us see. Okay. Heard Sri N.J. Khatanier, learned Standing Council, Elementary Education Department, for the applicants. Also heard. सबका नाम लिख दीजिए. Give a list who is appearing, in which cases. सिर्फ review में, हाँ, only the review. The hearing, these matters were heard on लिखा नहीं last order to. Last order नहीं है तो episode order করতুন খবরটা মারি বলে কেন নাম না মারা ব্লক বুঝি না পা last order না नहीं হয়েছে না.
It was hard on 22nd July, madam. 22nd July.
Good order. খবরটা মারি বলে গেলে were heard on so and so date, and
22nd.
further hearing has taken place today. Post of hearing is concluded. and judgment is reserved. Okay. This will be only in the review application, sir, not in the contempt. Contempt we have already filed past orders. Okay. Yes, we'll consider.
Obliged.
Review. Okay. Pune appear is Please give a list. All who are appearing in the review for the writ petitioners, opposite parties, please give a name and the numbers. 8. Contempt malaga. Review. 121 already. Okay.
Obliged.
Contempt order diya hai na pisat segregate. Contempt we are not having today. We'll first consider passing of orders, then we'll have. In the contempt you write,
Can a date be fixed?
huh?
Can a date be fixed?
Now we'll have the orders pass first.
As you know.
The connected review petitions have been heard today and judgment is reserved, full stop. List these cases after 3 weeks.
Fixing a date, no?
We're not fixing it. It will depend on the judgment when we deliver the judgment.
But the contempts against which the reviews are not filed, suppose my case, my lord, item 33, there is no review pending against me.
Understood. So those will be taken after the judgment. All contempts.
We pray for a shorter date when possible. After 3 weeks, my lord, any.
After it may be tomorrow also if we pass the judgment tomorrow. Mr. Chamo, what is this kind of judgment? Give us some liberty to pass the judgment. What have we said? You need a shorter date.
But not beyond before.
What? We have said 3 weeks.
Well,
be reasonable. Why have we said 3 weeks?
I'm also praying for a date.
Why have we said 3 weeks? Can we say that we are passing the judgment tomorrow or day after?
No. I'm
then
not saying that.
Why have we said 3 weeks? Only to give a leverage that after the judgment you can have the liberty to mention the matter. What is this kind of give a date? In all cases we are giving dates.
Well, I'm praying.
Tell us one case where we have not given dates, even for mention. Why we have not given a date in this matter? Can't you apply your mind? There is a judgment which is pending, which we have to deliver. Then we'll have considered the contempt. We cannot say that we are going to deliver the judgment day after tomorrow. We are giving an adequate, reasonable time of 3 weeks. Thereafter, make a mention, depending on the judgment.
Well,
yes. Chakraborty.
We tried to contact the other side, they are not receiving the phone call.
Mr. Chakraborty is there. B. Chakraborty, I think.
KL Gupta is also there.
Yes, please have them. These are part-heard matters. We like to finish off these matters.
Right.
Wait, please, your lordship. May this matter be passed over for 5 minutes? My senior is in.
Who is your senior?
Teacher.
Okay, after a while. I think your part is already over.
Just record was called for my daughter.
Yes, we'll have the records and we'll
Yes, madam.
either pass the judgment today or reserve it. Okay. Yes, what is this?
May I please?
Yes.
Lordship, matter pertains to the rejection of the capital investment subsidy.
You will be representing whom, Mr. Borwa?
For the state industry department,
Okay. Affidavits have been filed.
we have filed our affidavit. Lordship.
Yes. 175,419. Yes. What is it about, Mr. Tudi?
Lordship, the capital investment subsidy, central capital investment subsidy 2007. The claim for the subsidy has been rejected by the state level committee by taking an interpretation which is not within the scheme.
Yes.
May
Where is the
take-
rejection order?
Lordship, the
Page. Date of rejection.
The first rejection by the 48th state level committee dated 9/5/2018
9/5/18, it was rejected.
rejected first
Page
rejection.
45.
Page 45 or 46, Lordship,
46. Let us pay
Annexure
40.
5. Then there is also a second rejection, Lordship. 45 is 46 is two type copy, Lordship, of the minutes of the 48th state level committee for 30% CCIS below 1.5 crores under NEIPP held on 9/5/2018. Lordship may turn to page 47, the second paragraph. May I read, Lordship?
Yes.
In respect of the expansion claim,
This was a consideration of your case.
it was an overall consideration. Then my specific consideration is a subsequent page, Lordship. In respect of the expansion claim, it was informed that as the basic objective of the expansion was to enhance the production, productivity, employment, and bringing efficiency and reduce the cost of production, etc., these aspects should be reflected in the production figure filed by the unit to excise tax board,
Keyboard.
employment, sales tax, income tax, etc. Accordingly, as per the decision of the previous SLC, these admissible informations were sought from the expansion unit and placed along with the claims. So this consideration in my humble submission.
Yours was a case for expansion, not a
Expansion.
new unit.
No, it was a expansion. So this consideration is not within the scheme. Then a Lordship may turn to page 48. I am giving a true type of the my particular industry, which is Star Paper Board. Lordship may see the bottom right column, decision of the SLC. Though the unit has invested more than 25% in plant and machinery for their expansion, it doesn't corroborated and supported by the increase of production, power, VAT and CST return, hence the claim is rejected. My claim was for the last column, your Lordship will find 96,44,528.
Okay.
49 onwards is the original minute, Lordship, which was uploaded on the website, which is not legible. So I've given the two type.
What? Oh, okay.
Then, Lordship, after this rejection, page 66, annexure 6, I have given a representation for reconsideration. Then the Lordship may come to page 68, annexure 7. This is 54.
66/12/7/18. Representation for reconsideration.
For
Okay.
reconsideration.
Okay.
It was again reconsidered by the 54th state level committee dated 7/1/2019.
Page?
Page 68, annexure 7.
What is the date?
7/1/2019.
Reconsidered.
Reconsidered. 54th state level committee.
Okay, thereafter?
Lordship may turn to page 71. Which is a consideration, whether the page is legible to your honor.
Yes, which part?
The top part, Star Paper Board.
Star Paper Board, yes.
Yes. So the first column, your Lordship will, first row, your Lordship will find, as per decision of the 48th SLC held on 4/5/2018, the claim was rejected due to the unit has invested more than 25% on plant and machinery,
What is 45 or 95? 45,
Lordship.
45 or 95? 46. Page 46. They have
Page-
writ-
Page 46 is 48 SLC.
No,
dated
no,
9
not,
2018.
I think it is 45 because they cannot make a mistake.
Lordship.
45. You have, while typing, I think you have written 95. It should be
Oh.
45.
Lordship is referring to.
They have referred to the earlier meeting whereby it was rejected. The date has been restated as 45. In your type copy, you have written 95. So probably it will be 45. At page 71, the first line, Ms. Dr. Trudy, why don't you get it? As per the decision of 48 SLC dated
Yes.
45.
45.
So you have written 95 in your type copies.
No, but
Prob-
it is 95, Lordship. In fact, this 45 is mistake.
Is it 95?
Yes, Lordship. The original minute, Lordship, will find page 49.
49.
The top two lines, Lordship. 48 SL State Level Committee for 30% CCS under NAPP held on 9/5/2018. This 4/5
They'll not make a mistake. I think it's 4-5. Let us see the signatures. Oh, but that is not the controversy, isn't it?
Not at all.
Whether it's 9-5 or 4-5?
Yes. So here they are referring to the 48 SLC. Then they may I read, Lordship?
Just a minute, please. Photocopy appears to be 9-5. You're correct. Photocopy also appears to be 9-5. Right?
Yes.
Okay. Then what happened?
Here they have narrated the earlier SLC observation. As per decision of the 48 SLC held on 4/5/2018, the claim was rejected due to the unit has invested more than 25% in plant and machinery. For the expansion, it does not corroborated and supported by the increase of production, power, VAT and CST return. The unit has further appealed to reconsider the claim as there has
Same
been
decision they have taken in the reconsideration.
exactly, Lordship. Decision of the SLC, the fourth row,
Yes, we have seen this.
Lordship. So on the same ground, they have rejected it.
But they have taken into figure that there is no increase in the production.
Yes. But my case is that there is no such requirement under the scheme, Lordship, to evaluate the increase in production with the expansion eligibility. There is no such requirement of corroborating and supporting increase, nor there has been any prescribed criteria under the scheme.
So how do you ascertain
Lordship, may
that you have made the expansion by 25%?
Lordship, that's
Is this one of the factors from which the claim of expansion can be supported?
No. This is not at all a factor, Lordship. Because how the procedure runs is, once I make an expansion, before that I have to take a registration under the scheme. I take a registration, I apply for expansion. After expansion, I submit my application for expansion. The District Industries and Commerce Center makes an evaluation and field visit. After that, they make a report and forward it to the Commissioner of Industries for placing it before the state level committee. Once that comes before the state level committee and it is found that all expansion has been made, they verify all my bills and everything. Then the state level committee has to scrutinize as per the eligibility under the scheme. They have no further scope to that. They have to scrutinize only as per the eligibility conditions provided under the scheme. Once it is found that I am eligible, they have to give a sanction to the application and the amount claimed for. Then that once
In other words, you say that there is a continuous kind of a monitoring
yes,
by the authorities on the aspect of expansion.
exactly.
Once that have been done, you cannot just bring in the aspect of production.
Yes.
That there has been no commensurate increase in production and therefore you are not entitled.
Right.
You are saying that the criteria is an expansion by 25% which is under monitor
based on investment.
and based on investment, which
Yes.
is found to be correct, and therefore rejection on the ground that there has been no commensurate expansion, production, increase in production is not a correct method.
Right, because those are peripheral factors, Lordship. Production based on the demand, I may increase, I may reduce. Based on my capacity of the machinery, the electricity bill may reduce. There was change in taxation system in 2017. GST provision came in, so there was reduce in taxation. So those things are peripheral factors. So those cannot be considered, and those are not part of the scheme as well. May I take your Lordship directly to the scheme for that? Page 25. 25, Annexure 1. This is the Northeast Industrial and Investment Promotion.
2007 scheme.
2007.
NEIP.
NEIP. Dated 1/4/2007.
NEIP 2007. Dated 1407. Yes.
Lordship may first come to paragraph 1. That is the preamble or the object of this NEIP. The government has approved a package for fiscal incentives and other concessions for the northeastern region, namely so and so, effective 1/4/2007, which inter alia envisages the following. So this is a fiscal incentive as a package provided for industrial units. Point 1 is the coverage, which specifies that it covers the states of Arunachal Pradesh, Assam, Manipur.
That is
Meghalaya.
okay.
Lordship.
Not.
Important part is point number 2, duration. All new units.
No, Mr. Todi, come to the point which may be taken into consideration for the rejection. They have not rejected for duration or coverage.
No, Lordship, why I'm speaking is what the scheme provides. Based on what the scheme provides, they have to evaluate. So what the scheme provides, that I'm referring to, Lordship. The duration is, here says, all new as well as existing units which go in for substantial expansion. That is important part, substantial expansion, Lordship.
Mr. Todi, you did not plead the basics. We know about the basics.
Lordship.
Either a new industry or suspension
Lordship,
extension. Come to the
page
aspect of
26,
rejection.
page 26, point number 4, what substantial expansion means.
Yes.
This will be important, Lordship.
Point 4.
Point 4, what substantial expansion means. Incentives on substantial expansion will be given to units effecting an increase by not less than 25% in the value of fixed capital investment in plant and machinery for the purpose of expansion of capacity, modernization, and diversification.
Incentives on substantial expansion will be given to units effecting an increase by not less than 25%
of the value of fixed capital investment in plant and machinery.
Of fixed capital investment in plant and machinery.
Lordship. Then Lordship may come to point number 7, capital investment subsidy. The capital investment subsidy will be enhanced from 15%. Earlier it was 15%, Lordship. Now it is 30%. Will be enhanced from 15% of the investment in plant and machinery to 30%. And the limit of automatic approval of subsidy at this rate will be 1.5 crores per unit. So there is a provision of automatic approval, Lordship. Up to 1.5 crores per unit.
Please read again. Capital investment will be enhanced from 15% to
30%. Earlier under NEIP 1997, it was 15%. Now under NEIP 2007, it has been enhanced to 30%. And there is a provision for automatic approval of subsidy where the claim is up to 1.5 crores per unit. I have already shown to your Lordship that my claim is for 96 lakhs 44,000 and odd figures, Lordship. So under this NEIP 2007, the scheme of capital investment subsidy was floated, which your Lordship will find at page 30, Annexure 2.
30,
Lordship. Specific scheme has been formulated under the NEIP.
dated 27/7/2007. Point number 3, Lordship, applicability. Unless otherwise specified, all new industrial units as well as existing units which go in for a substantial expansion and are located anywhere in any year will be eligible for capital investment subsidy under the scheme.
Point number
3.
Yes. Yes.
Then again, point number 4, clause D, they have defined substantial expansion. Exactly the same language we have just read under the NEIPP, Lordship. The same definition for substantial expansion. Substantial expansion means increase in the value of fixed capital investment in plant and machinery of an industrial unit by not less than 200% for the purpose of expansion of capacity, modernization, and diversification. Then next page, Lordship, page 31, clause F. What do we mean by fixed capital investment? Fixed capital investment means investment in plant and machinery for the purpose of this scheme. Then the extent of admissible subsidy, which is 30%, Lordship, with automatic approval of 1.5 crore. Point number 5. And point number 6 is important, Lordship, which is a consideration. Plant and machinery for manufacturing sector.
Point number
6, Lordship. Yes. Point number 6, Lordship, is the consideration. And point number 3, 4D, and 5 is the eligibility consideration, Lordship. They will determine my eligibility, and based upon that eligibility, point number 6, how it has to be considered, Lordship.
Yes.
In calculating the value of plant and machinery, the cost of industrial plant and machinery as erected at site will be taken into account, which will include the cost of productive equipments such as tools, gigs, dies and molds, insurance premiums, etc. The amount investment in goods carriers to the extent they are actually utilized for transportation of raw materials and manufacturing of finished goods will be taken into account. Working capital, including raw materials and other consumable stores, will be excluded for computing the value of plant and machinery.
Yes.
Lordship. So, under this scheme, Lordship, point number 9, Lordship. Now, how it has to be evaluated by the state level committee. Procedure for disbursement of capital investment subsidy. Each state government concerned will set up a state level committee consisting of a representative of each of the state finance departments, state industries departments, state directorate of industries, net fee, and financial institution concerned. If the industrial unit is to be assisted by a financial institution, to go into details of each case to decide whether the unit qualifies for the grant of subsidy and also about the quantum of subsidy. So my qualification comes from point number 3, point number 4D, and point number 5. In consideration of calculation, how the plant and machinery has to be calculated, point number 6. Once this criteria is there, Lordship, in respect of substantial expansion, the District Industries and Commerce Center will file a report upon investigation, which is forwarded to the Commissioner of Industries Department, Assam, to be placed before the state level committee. And state level committee has to scrutinize my claim in accordance with the scheme. Now here, they have taken up this interpretation, which my Lordship, I have shown to a Lordship that there is no such requirement under the scheme. So they cannot come up and take anything which are of peripheral data, and they can determine my eligibility based upon that, Lordship. I'll rely upon the three judgments, Lordship, of this Honorable Court, where interpretation of the scheme has been discussed, Lordship.
Please give the citations.
Lordship, first is 2005 10 SCC 554, which is Under Secretary, Ministry of Industries and Commerce versus Markand Textiles Industries and Other.
2005 10 SCC.
554. Under Secretary, Ministry of Industries and Others versus Markand Textiles in Industries
Paragraph
Private Limited. Paragraph 8, Lordship.
8.
8. May I read, Lordship, paragraph 8?
Paragraph 8.
Lordship.
Yes, please read.
The scheme floated by the state releasing grant of subsidy for industrial units to be set up in certain selected backward districts areas have a benevolent and public purpose to achieve, and that is to promote the growth of industries in such district areas which but for the state encouragement would continue to remain backward, and the industrial investment will not be attracted to such areas. Such scheme have to be constructed
Construed.
Sorry, Lordship. Such scheme have to be construed with practical and pragmatic approach so as to achieve and not frustrate the purpose sought to be achieved. The benefit of the scheme ought to be allowed if it can be done. The application should not be dealt with a hyper-technical approach or in a pragmatic manner. If the application
Pedantic, not pragmatic. Pedantic. Pedantic manner.
Pedantic manner. If the application filed before the cutoff date is substantially in order and satisfies the formalities expected of the scheme, then an opportunity should be allowed to the applicant to cure the defects which are not of substantial nature or are capable of being cured so that the deserving unit are not left out of the scheme. In this particular case, Lordship, what had happened? The application for claim was filed after the cutoff date. Honorable Supreme Court has allowed that even after cutoff date, it can be permissible. Then I'll rely upon Lordship, this Honorable High Court's judgment. Citation is 2020 1 GLR 119. Imami Limited versus Union of India. This was in respect of investment subsidy, Lordship. I'll rely upon paragraph 31, 32, and 33. Here the Honorable High Court had looked into the scope of state level committee.
31, 32.
And 33, Lordship. Here the Honorable High Court has looked into the scope of state level committee in taking its own interpretation, the scheme, the provision of the scheme. This is exactly the same scheme which present case is related to, Lordship, Central Investment Scheme. Paragraph 31, the short point for consideration is whether state level committee was justified in not considering the investment made in plant and machinery which were installed after the date of commercial production. Para 32, as per the policy, all new units as well as those going for substantial expansion commencing commercial production within 10 years from the date of notification of the policy would be eligible for the notified incentive and exemptions. The scheme framed to give effect to the policy defines substantial expansion to mean increase in value of fixed capital investment in plant and machinery by not less than 25%. New industrial units has been defined to mean an industrial unit for setting up of which effective steps were not taken prior to 1/4/2007. What are effective steps have been explained under clause 4E. In so far extent.
Mr. Dr. Todi, can you show us any precedent whereby the present consideration made linking your expansion with the production aspect has been dealt with by this court? These are general propositions. There is no dispute to these propositions. How the scheme has to be construed.
And the scope of this.
Now your claim has been rejected by linking with your production capacity.
Lordship.
They have not disputed that you have increased your made substantial expansion as per the scheme to the extent of 25% or more. But they are also taking into aspect that there is no commensurate increase in the production. Whether that's a relevant consideration, relevant, has it been dealt with by
No,
in any earlier case?
no cases come up in those matters,
Okay.
Lordship. There was one case, Lordship.
So
where-
these cases which you are relying upon lays down the general criteria
Lordship,
how
it is
this scheme
scope
is to be.
State level committee. Para 33 is important, Lordship. Scope of,
3-3.
yes, Lordship.
Yes.
Viewed in the above context, resolution of state level committee dated so and so that plant and machinery purchased and installed after date of commercial production should not be considered as admissible investment is a deviation from the policy and the scheme. Mandate of state level committee is to go into details of each case to decide whether industrial unit qualifies for grant of subsidy and also about quantum of subsidy. What state level committee has done in this case is that it has laid down some kind of a policy as per which purchase and installment of plant and machinery after the date of commercial production would be considered as inadmissible investment. It is not only beyond the policy and the scheme, but also runs counter to the policy and the scheme as discussed above. As discussed, it is not the purchase and installment of plant and machinery post date of commercial production which is relevant, but what is relevant is the relatability of the investment in plant and machinery to commercial production of the industrial unit. So here Honorable High Court has laid down the state level committee cannot go beyond the policy. The policy clearly says that I have to make a substantial expansion by investing more than 25% in plant and machinery, which is done, which is not disputed, Lordship. After that expansion, I have filed my claim application. Once it is found that I am within the state of Assam, I have made a substantial expansion within the time period. So there is no question of other interpretations and comparisons on peripheral factors to deny my claim, Lordship.
And the last one, Bhavani.
Bhavani, Lordship, para 28, which speaks about the purpose of NEIPP 2007. It has been discussed, Lordship, in this case. 2018 5 GLR 89. I'll not repeat, Lordship, because discuss the scope of NEIPP. What is the purpose?
Okay.
Now, Lordship, coming to the affidavit filed by the Industries Department.
Okay, to hear it later. Review to claim. Yes.
The only contention they have raised in paragraph 5. Oh, sorry, paragraph 7, Lordship.
By R3.
By R3. That with regard to the statements made in paragraph so and so of the writ petition, the claim of the petitioner was in most arbitrary so and so rejected by the state level committee. It is categorically denied by the answering deponent and begs to state that the Department of
Your which page?
running page 89, Lordship.
89. Paragraph
7.
Please read.
That with regard to the statement made in paragraphs 8, 10, 14, 15, and 20 of the writ petition, that the claim of the petitioner was in a most arbitrary and illegal manner rejected by the state level committee is categorically denied by the answering deponent and begs to state that the Department of Promotion of Industry and Internal Trade, DPIIT, had directed the Secretary Commissioner Industries via letter number so and so dated 24/2017 to obtain turnover, production quality, productive value, excise duty, return, employment generated, and VAT, etc. to 2 years prior to expansion, 1 year prior to expansion, 1 year after expansion, 2 years after expansion for the existing unit undergoing expansion. It is further begs to state that on the basis of the decision of the DPIIT, the Department of Industry and Commerce had obtained the documents from the existing unit undergoing expansion to ascertain the percentage of increase in production, employment, power, VAT, etc. after expansion compared to prior expansion, and the same was placed before the state level committee for decision after thorough examination. The state level committee observed that the increase of power, employment were not satisfactory, and therefore the state level committee took a unanimous decision to reject the claim of the petitioner. So first of all, Lordship, this letter is not in public domain. I am not aware of this letter, Lordship. Nor the respondents have brought it on record before your Lordship.
Which letter? 24, 2017?
24, 2017. Now, what that letter contains is not within my knowledge, Lordship. Even if certain direction has been done in terms of this letter, whether it was for the purpose of scrutiny of my claim is not clear, Lordship. And this internal communication cannot override the statutory purpose and the scheme provided under the NEIPP 2007 and the Capital Investment Subsidy Scheme 2007.
Okay. Yes.
The Lordship has asked whether this type of matter had come up before in any case. There was one case, Lordship, in respect of another industry, but there was no finding on that because there was again one letter by the DIPT which they have asked the industry department to reconsider the claim. Based upon that, that case was disposed of. What has happened to those claims, I am not aware of, Lordship. So there has no persuasive precedent, Lordship. I have not relying upon it.
Yes,
Yes,
Mr.
Lordship, in our affidavit filed by respondent number 3 in para 7, we have stated the reason why the state level committee had rejected.
You have
Yes.
relied upon a communication dated 24 to 2017.
Yes, yes, yes.
Where is that letter?
Somehow it was not brought into record, but it is there. So on the basis of this, certain information were sought for because certain procedures are there. Because the matter pertains to that.
So can you devise your own methodology, the SLC. SLC is a creature of a scheme.
Yes.
How to monitor. Scheme has said that either a new industry or an existing industry having substantial expansion of at least 25% in plant and machinery.
Yes.
You are satisfied on that you are not finding fault. You are finding fault with the aspect that there is no commensurate increase in production. If production was not a part of the criteria laid down in the scheme, can you reject on the basis of that? That is the question, precise question, Mr. Dr. Tudi is seeking an answer from this court.
Yes. That, Lordship, that aspect, how it is dealt.
See, Mr. Barua, State Council, your bona fide is not in doubt, but you have to act in the prescription of law. You may have many good things in your mind that I want to have another safeguard, whether the money has been properly utilized. There should not be wasted the public money.
Yes.
But in doing so, you cannot devise your own methodology. In that, if you do that, it will give rise to arbitrariness. Somebody may act fairly bona fide, somebody may have malafide intention, give hurdles after hurdles.
Because Lordship already.
So that is the only reason it is laid down that whatever the law prescribes, we have to do in that method, no other method. All other methods are forbidden. That is the expression Privy Council has used. If a thing has been prescribed to do a particular thing in a particular manner, only that has to be done. Otherwise, it's forbidden.
The main criteria of the scheme is substantial investment in the fixed capital investment.
That you have come to a satisfaction.
Because Lordship, in page 15,
yes,
the petitioner has given some cert. So all these things, Lordship, that has to be looked into by the authority by scrutinize all this because that valuation has been shown. In that chart, Lordship, that they have shown some valuation for land. Only the figure, Lordship. But that thing has to be scrutinized by the state level authority.
It was done.
Yes.
Wasn't it done?
And earlier, Lordship, that 48th state level committee, Lordship,
Yes.
they have rejected. That was not challenged by the petitioner, Lordship. And we again reconsidered. And here the challenge is made it on regard to that Lordship last SLC, 54th SLC.
Correct.
They have not made the 48th SLC.
Nonetheless,
Challenge.
nonetheless, they tried once more, and the rejection is on the same ground that there is no commensurate increase in production
Lordship.
Whether that
That-
can be
that-
an
that
essential
met-
ground.
That methodology, that methodology adopted by the authority, Lordship, because to avail the facility of subsidy, they have to scrutiny all things in scheme. Although because this is the procedure, district level committee, they will forward some report, and on the basis of that report, they will scrutinize, Lordship. Because foremost thing is a substantial expansion on the capital investment. Here,
On that, you seem to be satisfied.
yes,
If you read both the 48 and the second one, 54th,
yes.
you seem to be satisfied that there is an expansion of 25% of on fixed capital, plant and machinery.
Yes.
But rejection is only on the ground of there is no commensurate increase in production. This may be a relevant criteria, this may not be a relevant criteria. May be a relevant criteria, but this criteria is not prescribed by the scheme.
Government is giving subsidy to a unit, Lordship. So the basic.
No, subsidy to your unit for what?
That expansion, substantial expansion.
Expansion.
Yes.
The benefit, the incentive is not on the aspect of production. In that year, there may not be production. There may be many factors we do not know. But if you are satisfied on the aspect of substantial expansion by 25% minimum, then other criteria will it come?
Then Lordship, whether they adopt certain procedure or methodology, on that point, Lordship, I will talk with the authority, Lordship.
No, we are completing the hearing. Okay, we'll consider this. Mr. Gupta, you're for whom? Central government? Not much. Decision is by the state. Okay. That's all. Mr. Devanand, why are you here?
I came for report number 1.
You're enjoying the proceeding or not enjoying the proceeding?
I came for
You would have given you a privilege of hearing audience.
yes.
You have come for so
Sure.
far.
Right.
Unfortunately, you don't have a matter here.
Yes. I was thinking that I'll be the loss if after a long time.
Okay.
Right.
Matter is over.
Yeah, that is all.
Okay, we'll take a 5 minutes break. We'll dictate this in the court. The instant application under Article 226 of the Constitution of India has been filed, being aggrieved by the rejection and denial of a claim for reimbursement of 30% subsidy under the Central Capital Investment Subsidy Scheme 2007. Full stop. The primary ground of challenge is that such denial has been made by the state level committee on irrelevant and extraneous consideration, whereas the petitioner claims to have met the fulfillment criteria. As per the facts projected, the petitioner, a scheme was announced in the name Northeast Industrial and Investment Promotion Policy 2007. A scheme in the name Central Capital Investment Subsidy Scheme 2007 was framed in terms of the Northeast Industrial and Investment Promotion Policy 2007, which amongst others provided for reimbursement of 30% of the total amount of investments in plant and machineries to eligible new industrial units as well as additional investment during substantial expansion to the eligible existing units undergoing substantial expansion. Full stop. The petitioner claims to be entitled for such reimbursement had filed its claim for the third expansion. Full stop. However, the state level committee meeting in its 48th sitting held on 9/5/2018 had rejected such claim on the ground that though the investment was more than 25% in plant and machinery, there was no corroboration and support in the increase of production, power, VAT, and CST return. Full stop. The petitioners had represented against such rejection, and the matter was taken up by the state level committee meeting held on 7/1/2019 in its 54th sitting. Full stop. However, on the similar grounds, the claim has been rejected. Full stop. Being aggrieved, the instant petition has been filed. Para. I have heard Dr. A to the learned counsel for the petitioner. I have also heard Sri S.R. Barua, learned state counsel. Full stop. Para. Dr. Todi, the learned counsel, has submitted that the entire objective of the scheme, as explained by a number of judicial pronouncements, is to have industrial development in the area, and accordingly, such claims are to be construed in sync with the objective. Full stop. He has submitted that the petitioner has fulfilled the eligibility criteria by undertaking substantial expansion of 25%, which is as per the scheme, and therefore was entitled for the benefits, which, however, has been rejected. Full stop. He has submitted that no criteria has been laid down that there has to be commensurate increase in the production. Full stop. He has submitted that such expansion has to be done in a transparent and open manner, which is under the continuous monitoring of the state God department. Full stop. By drawing the attention of this court to the NEIIP 2007, dated 1/4/2007, the learned counsel for the petitioner has referred to the aspect of substantial expansion as laid down in serial number small 4, which read as follows, page 26. He has also submitted that capital investment subsidy has been defined, which read as follows, number 7. The learned counsel has also referred to the notification dated 27/7/2007, by which the scheme was notified under the policy. Full stop. Under full stop. Paragraph 3 of the notification is on the applicability, and he submits that there is no dispute regarding the application of the said scheme to the unit of the petitioner. He has referred to the definition of substantial expansion as given in paragraph 4D, which reads as follows, page 30. similar definition, likewise, the definitions of plant and machinery and the procedure for disbursement of capital investment subsidy as laid down in the said scheme have also been pressed into service. Full stop. For ready reference, the above are extracted herein below, serial number 6 and serial number 9. The learned council has reiterated that nowhere in the policy or the scheme there is any scope to look into the aspect of increase in production or power, production, power, or for examination of the VAT and CST returns. Full stop. The learned council has submitted that peripheral matters cannot be the sole ingredients, sole ingredients to come to a conclusion for rejecting the claim of the petitioner when the petitioner has otherwise fulfilled the requirement of the scheme. Full stop. Para. In support of his submission, the learned council has relied upon the following case clause. Tinta case clauses 1, 2, 3. So in the case of so and so, we'll give a minute. Towards the end of his submission, the learned council, by drawing the attention of this court to the affidavit in opposition filed by the respondent 3 on 28/7/2026, has submitted that in paragraph 7 of the said affidavit, where the justification has been sought to be made for such rejection, there is a reference to a communication dated 24/2017, which was never served upon the petitioner, nor the same is in the public domain. Full stop. He accordingly submits that the reasons for rejection appears to be opaque and there is no transparency in the matter, which would require judicial interference. Per contra, Sri Barua, the learned state council, has defended the action. Full stop. He has submitted that though the petitioner had applied for subsidy under the scheme, the same was rejected by the 48th state level committee meeting, which was not challenged in any forum. Full stop. The petitioner had rather applied for further consideration, which was accordingly done by the state level committee meeting in its 54th sitting held on 7/1/2019, and again the same has been rejected. Full stop. He has submitted that when the original decision has not been put to challenge, the petitioner would be precluded from challenging the subsequent decision. Full stop. Para. On the merits, the learned state council has submitted that the factors which have been taken into consideration by the state level committee meeting are germane and relevant as production, as increase in production, power, VAT and CST returns are intrinsically connected with the increase in the with substantial expansion in plant and machinery. Full stop. He has submitted that the decision has been taken bona fide, which would not require any interference. As regards the communication dated 24/2017 is concerned, as mentioned in paragraph 7 of the affidavit dated 28/7/2026, the learned state council has submitted that the communication was issued by the central government to the respective state governments on the applicability of the subsidy scheme, which amongst others had the aspect of production in terms of quantity and value, comma, excise duty, comma, employment generation, etc. He has submitted that the action of the state level committee cannot be faulted with, as they had acted bona fide and in accordance with law. Para. The tribal submissions have been duly considered and the materials placed before this court have been carefully examined. Full stop. Para. The scheme wide notification dated what is the date of the scheme?
27/7/2007.
No, scheme,
Page 30, Lordship.
30. The
Dated-
scheme as per notification dated 27/7/2007 is as per the NEIIP 2007, which was announced on 1/4/2007. Full stop. Both the policy and the scheme by which this policy has been made applicable contain the definitions of substantial expansion, comma, capital investment subsidy, comma, plant and machinery, and also the procedure for claiming capital investment subsidy and disbursement thereof. Full stop. On a careful perusal thereof, comma, the only requirement is that for availing, for claiming such a subsidy, comma, there has to be increase in the value of fixed capital investment in plant and machinery of an industrial unit by not less than 25% for the purpose of expansion of capacity, modernization, and diversification. Full stop. Para. It is the specific case of the petitioner that such expansion has to be made after duly notifying the authorities, and the expansion is also monitored. Full stop. What is also relevant to mention is that in both the 48th and 54th meeting of the state level committee, comma, there is no denial that the petitioner unit had no substantial expansion of 25%, and the denial of subsidy and the refusal of subsidy is only on the ground that there is no corroboration and support by commensurate increase of production, power, VAT, CST return. Full stop. While the matter, while an application for subsidy is to be considered, comma, such consideration has to be strictly in terms of this policy and the scheme notified. Full stop. As noted above, comma, nowhere in the policy or the scheme there is any requirement or need to examine as to whether there has been any commensurate increase in the production, power, etc. Full stop. This court finds force in the submission advanced by the learned counsel for the petitioner that though the aforesaid factors may be relevant, comma, those cannot be the determining factors for denial of the benefits, as there may be various reasons for not having an increase in the production power or in the returns to be filed by an unit, full stop. What is important is with regard to the fact of making a substantial expansion of more than 25%, which is not disputed in the present case, full stop. Para. The judicial pronouncements, as explained above, has clearly laid down that the scheme is to be liberally construed if a unit otherwise meets the eligibility criteria, full stop. In the instant case, comma, there being no dispute that the unit in question has met the criteria of having substantial expansion of more than 25% in plant and machinery, comma, the refusal of the subsidy on the grounds cited are held to be untenable in law and accordingly set aside, full stop. This court is also fortified in taking the decision by the principles laid down by the Honorable Privy Council in the case of King Emperor versus Nazir Ahmed, AR 1936 PC 153, wherein the following observations have been made. Full stop. In view of the aforesaid discussion, comma, this court is of the opinion that the impugned decision of the state level committee taken on 7/1/2019 is unsustainable in law and is accordingly set aside. Full stop. The case of the petitioner is to be considered afresh, strictly in accordance with the policy and the scheme and in the manner indicated above.
Lordship may direct to be placed before the state level committee again.
Yes, we have said them.
Lordship. And
Such consideration is to be made expeditiously and preferably within a period of 3 months from the date of receipt of a certified copy of this order.
Lordship, one small prayer, Lordship. There is a prayer for grant of interest for delay, Lordship. That may be kept open, Lordship.
That were not.
There is no provision for.
That may be kept open. Matter is pending before the Honorable Supreme Court, Lordship.
That will not say anything.
Much open.
Let us clarify that, Mr. Barwa. At this stage, Dr. Todi has submitted that there is also a prayer for interest, full stop. Para. This court is, however, of the opinion that when the scheme does not speak about any such provision, comma, this court will refrain from making any such direction.
Much open.
Record was full.
Record is brought.
Just a minute. What is your name? Sorry.
C. Chakraborty.
So, Mr. Chakraborty, if we just recapitulate the facts, you were allotted a shop on 19/9/2023, correct?
My lord.
And you had started making construction.
My lord.
And you have also given certain photograph to support that.
Yes, ma'am.
Then on 29/11/2023, the allotment has been cancelled. And they have said that there was a server error. The Bheti was shown to be unoccupied.
Yes, sir.
And it was already occupied to one Mohabuddin. Respondent number 7, Mr. Chakraborty's client. But you said that you had already invested around 2 lakhs. And respondent number 2, 3, 4 has filed an affidavit saying that 55/1 was allotted and no permission for construction granted, in spite of which request to take refund is paying an incidental charge.
Municipal authority, they have annexed one unregistered agreement method. The duration of the agreement was initially 1 year, subject to renewal of the up to 3 years. But after passing
Unrenewal agreement with whom?
with the respondent number 7.
7, okay.
7. That was expired, my lord, my lord. Already 7 years was passed. As per the clause of the agreement, my lord, he has to construct the shop, my lord, but he has failed to construct the same. and according that was already expired. Thereafter, the reference number 7 also filed an affidavit, my lord. We have filed our reply, my lord.
Well, it is not going to. Yes, well. And Mr. Chakraborty, you said that the agreement was of 2016 and you have made the up-to-date payments. Number two, you have said that up to 31/11/2022,
Yes.
you had paid thereafter the case was filed and you were given permission on 36/2023.
The contract was given to me.
On 36.
Given to that.
Okay. Okay. Then this 55/1 RCC is the first floor,
First floor, my lord.
which is given to you. Petitioner has the ground floor. Petitioner does not have permission and there is no agreement. And without permission, he could not have made any construction.
Except depositing the money, there is no paper to show.
Permission to the petitioner to. And in 2007, petitioner has granted permission to construct ground floor, which he had done.
Shows that permission is necessary for construction. Here, without permission, he says that on a verbal permission, he has started the construction. Possibly. Permission is.
So in the allotment letter, there is, it is silent, my lord. So regarding the permission, seeking written permission, my lord.
Allotment of your allotment.
My lord. Annexure number 5, my lord.
Nectar 5. Just a minute.
The writ petition, my lord. Page number 24, my lord.
20?
Page number 24, my lord. The writ petition, my lord.
24.
My lord.
Yes.
No, where it is mentioned that it's money received, my lord. It is mentioned that there's allotment of petty, my lord.
No, an account of. It's
Yes,
a money receipt.
Yes, ma'am.
Money receipt on account of allotment. On account of. Why have you received this money? On account of. But we'll may not be very technical.
Yes, ma'am.
In absence of a allotment letter, we may not say that nothing, no right. Money receipts may show that something, some allotment was made in your favor.
It is with approved by the chairman and the.
But their main case is that there was server error. It was already allotted.
But that, regarding that point, my lord, their affidavit is silent, my lord. The what kind of server error, my lord? Everything was done through, my lord.
You have filed affidavit. You have.
They already filed affidavit, my lord.
Just a minute, please.
Only bona fide mistake on the part of.
Just a minute, just a minute, just a minute. Mr. Gupta, for our response number?
3 and 4.
2.
3 and 4.
Affidavit filed when?
20th April 26, ma'am.
Okay, 34. Page 34. Yes, 34.
Mentioned in paragraph 8.
24, 26, please, 30. Where have you mentioned?
Paragraph 8.
Paragraph?
8.
8.
Of our affidavit.
Please read.
Page 37.
Please read.
With regard to section paragraph 5, 6 of the application, the answer in this one states that the by letter dated 1990 issued by team municipal board only 18 number people allotted to the petition. No permission was issued. In fact, permission was required for just allotment was made. But subsequently, when we learned that it was due to server errors, we have immediately cancelled it by letter dated 29/11 after 2 months. The answer is you did not accord any permission for construction of the petition over the BT number. However, immediately having come to know about the error in allotment of BT to the petitioner, answer in this one cancel the allotment of BT number 55 one of the one file data number dated 29/11/2023. We have immediately answered and make application regulated for them also. Make application also. In 48, page number 48, we intimated to the minister.
My lord, after allotment, after construction, starting of construction, after 2 months, my lord, they have seeking apology, my lord. After investing my money, my lord. The market was sitting in the prime area, my lord. Near to office, my lord. It was totally, my lord, surprising that they did not have the knowledge, my lord. After 2 months, they have come, my lord.
When it came to knowledge of the board municipal court, immediately we intimated the petitioner and wrote letter to them and take apology also. That I've requested them to take refund of the money.
Another point, my lord, the private.
Just a minute. Let us one by one. Mr. Chakraborty, have your seat.
Sorry, my lord.
One by one. We want to have the look at the records regarding the allotment to Mr. Chakraborty.
It is in the register website matter. Yes. Pink flag. It 1617 it has already been allotted. Serial number 602. Serial number 602 already Mahibuddin Adhikar name is there. It's not that it's after thought decision. At that time.
Just a minute.
602.
Well, where do you get the Veti number? Oh, 55 by 1. Okay, okay.
Original agreement is there in the record document. And in case of everybody, agreement was not registered. In fact, petitioner is also in occupation of ground floor premises. That has also been registered. And that has also been not renewed. So far my instruction goes. Their agreement is also.
Just a minute. It appears to have been allotted to Mr. That we wanted to see whether it is a made-up story or not. But you may be correct in contending. What were they doing for 2 months?
The other point is, the respondent number 7 has.
Have you finished, Mr. Gupta? Anything else? What is this this file? What is this? What is this file?
This is the procedure of allotment of the payment to the petitioner. Initially, it was allotted on 18/9, and then immediately having come to know, we have cancelled. And the proceeding is there in the record. And Mohammedan Hajir correspondent 7 is also paying the rent regularly. Though his agreement not been renewed, but he is paying the rent. In case of every receive agreement has not been renewed, he is paying. His agreement is not been cancelled.
Stand taken by the municipal corporation is also, my lord, quite suspicious, my lord. Only to save the respondent number 7, they have said all are backdated document, my lord. It is all are backdated document, my lord.
No,
this.
My lord, respondent number 7 and file affidavit, my lord. They bring an order, my lord. That order was not in their affidavit, my lord. Only filing his affidavit, they appeared in this case, my lord. Respondent number 7, my lord. They bring an order, my lord. That order was not in the order in the affidavit of the municipal corporation, my lord.
Which order?
Yes, my lord. Sir, kindly.
for giving allotment to me, 3 months prior to that, permission for construction was given to me. Then means to say that this order, why the municipal board did not annex this order? Why?
No, Mr. Chakraborty can also, because this was delivered, it was furnished to him. There cannot be, this cannot be give rise to any suspicion. But so far as your contention that there is no registration or renewal, he says that even for your arrangement, there is no registration or renewal.
In ground floor premises, there is no registration. His
But
agreement is
what
also
do you-
not been renewed.
what do you say?
That he cannot take a stand like this.
But that is not, this is
It
not,
is usual
we have to take the
practice.
instruction, my lord.
In every case,
Where have you stated? Have you stated?
that is not been stated. But on the, I have the instruction that his agreement has also been reviewed. And his agreement also been not registered.
But the original records fortifies that it was indeed a bona fide mistake. 55/1 was given and it was not cancelled. But from, but it was given to Mr. Chakraborty when? 2016. Why you have not done the construction?
7 years has passed, my lord.
My affidavit has stated, my lord, permission and construct, until another permission for construction given, he also could not do it without permission. Permission has been given, then only I could do it.
Permission given when?
Recently, 3 months prior to their allotment.
My lord,
That would be,
But since they have.
page 66, double six.
the agreement I executed in that 16, my lord. After 7 years, the municipal authority given permission to construct, my lord. It is so surprising, my lord. After
My lord, he did it, I did not do it, my lord. Forcibly, I mean, the amount deposited and started construction in a, that I did not do.
Well, after investing the,
Permission I have.
after investment of my that 2 lakhs money, now they are cancelling, my lord. Everything, I have lost everything, my lord. I will remain less, my lord.
What did you?
But there is also the difference between the square feet, my lord. The pharmacy allotment allotted to us and they are allotted to them. There is difference, my lord. The square feet, my lord. Area of that.
It's not the subject.
Correct. You know,
Only, my area was not fixed to, since the beginning. It is only the allotment. Whether that allotment was made earlier.
Construction
It has
was
come-
made.
come after-
Construction is
after.
absolutely unauthorized. Construction, how, my lord, depositing the money, one can, construction, my lordship, can you see my permission? That has to be a plan, that has to be conformed to. That has to be given by the authority, then only the construction. Depositing the money, starting the construction, absolutely unauthorized.
How do you go to your first floor without, there is another route? If he doesn't allow you to go to the first floor,
The staircase is different.
different staircase.
outside. them.
Mr. Chakraborty, why is your friend sitting on the back? Mr. Bhomik?
So we maintain a distance, my lord.
Huh? You maintain a distance. He maintains a distance with you nowadays. Mr. Bhomik, yes. He said that he maintains a distance. It's unsafe, he says.
It belongs to the privileged class.
Privilege class, okay, okay. We have understood. We'll not ask any further question. The instant petition under Article 226 of the Constitution of India has been filed seeking the following relief prior to Court Codipa. Para. The facts projected in brief is that the petitioner is having a shop at Bheti number 55 of Dhing Bazaar, ward number 6, which was duly allotted to him. Full stop. He had applied for a Bheti in the first floor of the newly constructed RCC building. Wide application dated 18/8/2023. And after verification, he was allowed to deposit an amount of rupees 30,288 for such allotment. And the allotment order dated 19/9/2023 was issued in his favor. Full stop. The petitioner started the construction and claims to have spent a considerable amount, whereafter suddenly, the executive officer, Thing Municipal Market had issued the impugned letter dated 29/11/2023, cancelling the allotment by stating that due to server error, the Bheti was wrongly allotted to the petitioner. Full stop. It is this action which is the subject matter of challenge in the present writ petition. Full stop. I have heard Sri J. Roy. We record Mr. J. Roy, Learned Senior Counsel, assisted by Sri Chakraborty. I have also heard Sri K. Gupta, Learned Counsel for the respondent numbers 2, 3, and 4 within bracket Dhing Municipal Board. And Sri B. Chakraborty, Learned Counsel for the respondent number 7. Full stop. Miss Udas, Learned State Counsel, is present for the state respondent. Para. Sri Roy, the Learned Senior Counsel, has submitted that while the allotment was made to the petitioner of the Bheti number 55/1 on 19/9/2023, all verifications were made, whereafter the petitioner had also started construction. Full stop. He has submitted that the allotment has been done on extraneous factors to favor the respondent number 7. He has submitted that though the materials have been placed to show that the allotment was previously made in favor of the respondent number 7, such allotment appears to be of the year 2016, and the very fact that no construction was made for all this period would show that such allotment did not practically take place. Full stop. He has also submitted that from the date of allotment on 19/9/2023 till the date of cancellation, that is 29/11/2023, more than 2 months had passed, in which period, the petitioner had also made constructions which were done openly and noticed by the municipal board, whereafter no action was taken, and suddenly after more than 2 months the impugned action has been taken. Full stop. He has submitted that though an agreement has been shown to be made by the Dhing Municipal Board with the respondent number 7, such agreement was for a period of 1 year with a renewable clause, and there was no renewal. Full stop. He has submitted that under clause 18 of the said agreement, if no renewal is done within 3 years, such allotment would be cancelled. And by the application of the legal fiction, comma, the allotment, if done with the response number 7, stood cancelled. Full stop. The learned senior counsel has also submitted that only on 21/12/2023, the petitioner was notified not to go ahead with the, not to obstruct. And in the meantime, comma, sufficient investment was already done. Full stop. By drawing the attention of the affidavit in opposition of the response number 7, comma, the learned senior counsel for the petitioner has submitted that only on 3/6/2023, the permission has been given to the response number 7 to make the constructions, which itself shows that the action has been 36 or 36? 36, I think. 36 or 36? Page 66? What is 36 or 36? Which gives an impression that the papers have been manufactured. Para. The learned senior counsel accordingly submits that the impugned order of cancellation is liable to be interfered with. Para. Per contra, comma, Sri Gupta, the learned counsel appearing for the contesting Thing Municipal Board, has submitted that affidavit in opposition has been filed on 24/2026. He has submitted that on 19/9/2023, due to server error, comma, Bheti 55/1 was allotted to the petitioner. Full stop. He has submitted that when the same mistake was detected, comma, the communication dated 29/11/2023 has been issued cancelling the same and requesting the petitioner to take refund of the allotment amount. Full stop. He has submitted that the Bheti was allotted to the response number 5 in the year 2007, in the year 2016. And only due to server error, comma, the Bheti was wrongly allotted to the petitioner. Full stop. When this matter was taken up for consideration on the earlier occasion, i.e. 28/7/2026, Sri Gupta, the learned counsel, was directed to obtain the records, which he has accordingly done. Full stop. Perusal of done. Full stop. On the aspect that no construction was made by the respondent number 7 in this period from 2016 to 2023, comma, the learned counsel has submitted that no permission was granted for various reasons, and therefore construction could not be done. Full stop. He has also clarified that though the agreement of his client with the respondent number 7 dated 13/10/2016 was not renewed as a matter of fact, comma, he has been paying the monthly rents on time, and there is no default. Full stop. He has also submitted that the petitioner himself is allotted the ground floor of the same building in connection with which there is an agreement which is also not renewed and not registered. Full stop. Para. The learned counsel accordingly submits that the order, impugned order dated 29/11/2023 does not suffer from any legal malice and accordingly this writ petition is liable to be dismissed. Full stop para. Supporting the decision making process, comma, 3B Chakraborty, learned counsel for the respondent number 7, has submitted that it is clear that the allotment made, that the arrangement made with the respondent number, with the petitioner on 19/9/2023 was a result of an inadvertent mistake. Full stop. He has submitted that as a matter of fact, comma, no allotment order as such has been able to be placed before this court, and the communication relied upon is only a receipt of the amount. Full stop. He has also submitted that the Bheti 55/1 was duly allotted to his client in the year 2016, followed by an agreement, and all up-to-date payments have been made. Full stop. He has submitted that with regard to the construction, comma, as permission was granted only on 3/6/2023, comma, the construction could not be done from the done in between. Full stop. However, in the meantime, the present dispute had arisen. Full stop. He has also questioned the authority of the petitioner to make constructions without any permission. Full stop. Para. The rejoinder submission has been made by Sri C. Chakraborty, learned counsel, who has submitted that the aspect of non-renewal or non-registration or non-renewal of the agreement of his client with the Dhing Municipal Board has not been pleaded in the affidavit and therefore cannot be raised. Full stop. He has also submitted that though no allotment or order as such has been served upon him, comma, it is not in dispute that the communication dated 19/9/2023, though is in the form of a receipt, will clearly show that allotment was indeed made for the Bheti 55/1. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court, including the original register and file of the Dhing Municipal Board, have been carefully considered, carefully examined. Full stop. Para. We have a meeting at 1:05. We'll complete this. Okay. Yeah, take complete for you. We have to raise. Last can you move for you, huh? This matter.
Yes. Mr. Chaudhary also there.
Let us try. We got delayed because of some meeting.
My lord. Yes.
Let us complete the judgment.
Yes. Yes.
Who is on the other side? Who's for the other side, your matter?
I'm there also.
Oh, that NIT debarment matter.
Yes.
Debarment.
Yeah.
Let us try. Let us try. Timanat Basili.
The judgment is pending.
Yes. Timanat Basili. Hold on. Private subsidiary. The challenge to the cancellation order dated 29/11/2023 is based on the fact that the petty in question within bracket 55/1 was allotted to the petitioner on 19/9/2023, full stop. Though there has been some resistance made on behalf of the respondents that the document relied by the petitioner is not an allotment order, comma. This court is of the opinion that the said document, though is in the form of a receipt, would show that the allotment was indeed made in the name of the petitioner on 19/9/2023, full stop. Under those circumstances, comma, it is required to examine as to whether the cancellation order is legally tenable and justified or not, full stop. The defense, the specific defense taken by the respondents, which is also reflected in the documents, is that the VT 55/1 was earlier allotted to the respondent number 7 in the year 2016, full stop. The petitioner has, however, submitted, this, however, contested the aforesaid aspect by stating that such agreement, such a defense has been, such defense is a manufactured one, as from 2016 onwards, there was no construction made by the respondent number 7, full stop. The same being within the realm of disputed questions of fact, comma, this court vied the earlier order dated 28/7/2026 had directed the learned counsel for the board to produce the original documents, which has accordingly been produced, full stop, to dispel and remove the dispute on this issue, comma, on the said records have been duly examined, full stop. The register which has been produced in original, however, clearly reflects that petty number 55/1 was indeed allotted to the respondent number 7, full stop. The aspect that the respondent number 7 has not made construction over the land would not make any difference to such allotment, as the allotment as such has not been cancelled, full stop. It is also the pleaded case of the respondents that the respondent number 7 has been making up-to-date payments to the board for the VT allotted, and it is also the case of the respondent number 7 that lack of permission to make construction was only the reason not to have any constructions done, full stop. It is on record that such permission has been granted only on 3/6/2023, prior to which the allotment, 26/6, and immediately thereafter, comma, the allotment to the petitioner was made by 19/9/2023, which has been said to be because of a server error, full stop. Para. Though it may be argued that by the allotment order dated 19/9/2023, a right has accrued upon the petitioner, taking into consideration that when such allotment was clearly made by error, by server error, and the VT was already allotted to the respondent number 7 way back in the year 2016, which is fortified by the records, comma, this court is of the opinion that the impugned order dated 29/11/2023 cannot be faulted with, full stop. The writ petition is accordingly dismissed, full stop. The petitioner would, however, be entitled to have the refund of the entire money deposited by him, full stop. The petitioner may also make appropriate application for compensation of the, not compensation, for reimbursement of the expenditure incurred for the construction. And if the same is done, comma, the same is required to be considered by the board and disposed of by a speaking order. Full stop. The writ petition accordingly stands disposed of. The original records, including the register, are handed over back to Sri Gupta, the learned counsel for the board.
What's all right?
Petitioner company is MSCME, my lord. They are manufacturing, my lord, this UPS system, batteries, backup solution, etc., my lord. And they are supplying goods, my lord.
Where is Mr. Chaudhary? Coming. You are an MSME.
MSCME.
What do you produce, manufacture?
UPS system, backup solution, my lord, these batteries. Electric equipment.
Thereafter, yes, Mr. Chaudhary, come.
They are supplying, my lord, they used to this for last several years, my lord.
To NIT.
NIT, my lord. And in fact, my lord, they are issuing, my lord, certificates also to various years, my lord. Now, what happened, my lord? It appears, my lord, some complaint has been filed against the petitioner, my lord.
Complaint filed. By whom?
Filed. So now, on the basis of the complaint, my lord, they have issued a WT message, page 89, my lord. I'm coming shortly. My lord.
Page 89.
89. Whether your firm has complied the minimum guarantee pay requirement.
89.
Right in
This is email
email.
by NIT.
My lord?
By NIT.
NIT. No.
Email by NIT.
Yes. Institute. NIT. Yes, sorry. My base. NIT. Whether your firm has
just a minute,
complied the
89.
minimum guaranteed pay requirement.
What is the date? 16 September
Yes.
25.
My lord.
Email.
Provided detailed justification, so and so, so and so.
Whether from complaint minimum guarantee, which required.
There means, my lord, volt ampere hour.
Hmm?
Volt ampere hour.
Wall?
Ampere hour. Ampere.
Voltage.
Ampere hour.
Ampere.
What is that?
Is the capacity. Fixed capacity of the
Batteries.
product.
Whether complied with.
Now, my lord, these batteries were supplied, my lord.
Yes.
EPS were supplied long back, my lord. And particularly, my lord, what happened? They have issued certificate in respect of some also, my lord. Your losses will come to page 95. My lord. They have mentioned.
Did you respond to this or not?
Yes, my lord.
You had responded to this email?
Yes. No, we have been informed, my lord, verbally informed them everything. Now, if your losses find, my lord, these two numbers are 807 and 579. Page 95, my lord, 807, your losses find, my lord. The last two.
What are these?
Statutory my lord certificate. That was issued my lord. Is a placed order in 24 itself, my lord. And we supplied it on back. Many other certificates are there, my lord, with respect to other voters.
Yes.
Now, my lord, on the after 2 days, my lord, they have issued another mail.
Where is it?
That is page 90.
90.
90.
This is dated 18/9.
18/9. Then, my lord, the debarment order has been issued. On that day, my lord, we have approached them, we have explained everything. Now, next page, my lord, page 92, 91.
91, yes.
Subject is ban notice due to malpractice in training process. It has been observed that your firm is engaged in practice which are not are inconsistent with the principle of fairness and transparency expected in the tendering process. Such conduct constitutes a serious violation of the integrity and sanctity of the procurement process and is contravention of the rules of guidelines laid down under GM. Accordingly, the competent authority has decided to suspend your firm from participating in all tenders issued by the National Legislature for a period of 2 years from the date of issue of this notice. And directed to take note of this direction. Any bid submitted by your firm or under any associated name during this period ban shall be summarily rejected. This action is taken at all the issues. My lord, no so far, no hearing, my lord. Nothing is there, my lord. And they have submitted their affidavit, my lord. In the affidavit also, my lord, nothing there, my lord, no focus, my lord. Reply due. This is not. That affidavit.
NIT file affidavit.
Yes, and if I will file reply.
Which date?
You see that page, my lord, 100 onwards.
Two and three.
Yes.
Yes.
So here, my lord, they also have not anything, my lord. Nothing is there, my lord. In this aspect, my lord, I can submit, my lord, the different input, my lord.
Which one? Gorkha?
Gorkha, prior to that also, my lord, one judgment is there.
The first one, Erosion.
Raghunath Thakur, my lord.
Raghunath Thakur, Erosion equipment.
Not brought, my lord. That is mentioned.
First one, Erosion equipment and chemicals.
Erosion, I have not brought, my lord, but I'm giving, my lord. The erosion is mentioned in the Gorkha, my lord.
Raghunath also mentions erosion.
Yes.
Raghunath Thakur.
Yes. Then subsequent, my lord, latest decisions are there. Daffodils 1, my lord, 2020, and one SBI matter is there.
Erosion equipment has been taken into consideration in Raghunath. Erosion is 75.
Yes.
Gorkha is more extensive.
Gorkha is. My lord, para 21 mainly.
Of Gorkha?
Yes.
1989. 1 SCC. 229. Raghunath, which paragraph? 4.
Yes, my lord. And subsequent decisions are also there, my lord. One daffodil is there. Supreme Court.
Gorkha, which paragraph?
Gorkha paragraph 21, my lord, 21, 22. And daffodil is there, my lord. Daffodil. Yes. Daffodil, my lord, paragraph 14.
Paragraph?
14. And in the this SBI case, my lord, that is only one small paragraph, that is 98.4 at last page 47.
Page, paragraph?
98.4.
98.4.
And there are 3-4 judgments of our High Court also that not only so called, my lord, hearing should also be given, my lord. That is 98.4, my lord, that is. And Gorkha has said how so called notice is to be issued, that is paragraph 1. Paragraph 21 and 22. Everything should be given the so called notice, and what action will be taken, that also must be mentioned.
Okay. Yes, Mr. Chaudhary.
Here in this case, the.
You have for response number?
2 and 3 lordship. Here in this case, the petitioner company, while submitting the deed lordship, there's some sort of technical specification was there. And that technical specification was.
You only argue on the decision-making process. Don't argue on merits.
Because with regard to the decision-making process, lordship, my lord, senior has pointed out with regard to the communication that was given.
Yes.
Email communication.
Correct.
Page number 89, lordship. Page number 89. And in response to that page number 89, lordship, this they have admitted the fact, and we have specifically mentioned in our affidavit also, lordship, they have admitted the fact that in our affidavit in opposition is the page number 158. Your lordship kindly presents that
158.
Yes, lordship. Right. Clarification against gem beat number such and such.
Email.
Yes, email communication.
There is 163.
Yes.
18 September.
18 September. 158. 158. Yes. 158 or 160?
No, 160. There is a change in numberings.
Okay. Yes.
The office, I do not know why they changed the numbers. What is there? It should be.
Exactly, lordship.
It should be maintained. There is no question.
Senior's copy also it is 158.
No, we find that most of the times pages are cut and new numbers are there.
Subsequently, the numbers have been changed.
No, even if there's one affidavit which should come later, it has come above. You should not change the numbers. Let it be. There is no problem. Once numbers are not matching, it becomes a big problem. Okay, 163. What, email dated 18/9/2025.
Yes, Lordship.
Okay, whatever. Yes, tell.
In that particular email, if you Lordship kindly see the below portion.
Yes.
that we have already mentioned in the catalog that we will provide 120 AH batteries of 16 numbers. However, as per your requirement, we will now be providing the following. This the calculation is there 32,256 VAH. So here, this particular response letter from the side of the petitioner company goes to show that the technical at the time of this technical specification which was quoted, there were some apparent anomalies on the part of the petitioner company. So in that view of the matter, this the authorities has taken a stand that since these anomalies were delivered on the part of the this company to get this particular NIT. So in that view of the matter, considering the apparent anomalies on the part of the petitioner company, they had decided to issue this particular impugn order so far as debarring the company to participate for 2 years. So with regard to that particular communication, the impugn letter, we have given the clarification. Lordship kindly peruse at page number this 109.
One 109 is 114 actually. 114 paragraph 12
Paragraph number 12, Lordship.
is 114.
Then I'll go to the operating portion. This page number 113, Lordship. Then 11.
Paragraph
Paragraph number, this is page number 118, Lordship.
113.
113, it was.
Yes.
Originally it was 113.
Okay, yes.
In
What
the
is
absence of any response, Lordship kindly see the starting from that particular paragraph. This is a paragraph number 14, the last part of the paragraph number 14.
paragraph 14?
Paragraph number 14.
14,
14, Lordship.
that is
Page number 112 in my page.
117. You are referring to paragraph 14 or which paragraph?
Paragraph 14, Lordship.
You said you are referring
No,
to.
not clear, Lordship. It's paragraph number
Okay. Paragraph 14 you are
Paragraph
referring.
14, page number 117, Lordship.
Okay, that is 117. That doesn't matter. Paragraph 14. Yes, what do you hear?
This the answering respondent state the petitioner assert on the respondent issued while email communication regarding VA specification or allegedly under discussion, and after purported verbal clarification abruptly issued a ban notice without show cause. So the response is here, Lordship. Without show cause is denied as incorrect and misleading. It is submitted that upon receipt of the complaint dated 12/9/2025, alleging VH misrepresentation clarification regarding the ongoing tender was first sought from the petitioner on 15/9/25. Based on the petitioner reply in the said letter, which revealed VH deficit in the quoted configuration, doubts arose regarding the compliance in the earlier contract cited in the complaint. Accordingly, on 16/9/25, the petitioner was formally requested to provide detailed technical justification and VH calculation in respect of such and such, with a stipulated deadline of 17/9/2025. No reply was received with the stipulated time. A reminder dated 18/9/25 was therefore issued requiring submission by 18/9/25 up to 1 p.m. However, no clarification or supporting justification was furnished by the petitioner. In the absence of any response, despite written opportunity, and in light of the complaints supported by technical inconsistency already evident from the petitioner's own VH computation in the contemporaneous tender, the institute was justified in treating the allegation as substantiated. It is further submitted that the impugn ban was not imposed for a solitary or first-time lapse. Rather, similar specification deviation misrepresentation was found prima facie across multiple procurements, including the alia gem. So this is the continuous effort on the part of the petitioner company as well as the ongoing tender examined pursuant to the complaint. The recurrence of the same malpractice across bids established a pattern of non-conforming supply against the declared VA specification, warranting institutional action to protect procurement integrity. The ban was therefore imposed in accordance with the procurement rules by notice number 27/10/2025. And the decision was duly communicated on 13/10/2025 to all concerned. The plea of verbal clarification is untenable as contractual compliance in public.
Mr. Chaudhary.
Yes, Lordship.
There is a complaint.
Yes,
We are not judging the merits of the complaint. It can be a genuine complaint. And you have also notified him.
Yes.
That there is a
Several
complaint. There is a
occasions. Yes,
complaint.
yes.
There was no timely response.
Yes.
And therefore, you have made the statement that the institute's action was thus complaint triggered verification based at
Yes.
page, your page 113.
Yes, Lordship.
Verification based
Verification.
preceded by a written opportunity.
Yes.
Now we have to examine what is this kind of opportunity. In the opportunity granted, the opportunity has to make them aware that this is the kind of allegation, this is the kind of action.
Yes.
What do you have to say? Now you have simply stated that you do not seem to conform to 2GM,
Yes.
which they are also relying upon some certificate. For the time being, let us ignore this certificate. Certificate is not there, and your allegations are correct. But you have not even hinted that you are contemplating to take some action, not to talk about blacklisting. You have not even hinted. No doubt you had given, you had,
Yes, the written communications were.
yeah, you had given them a kind of a notice that this is, something is wrong. But it's not even a show cause, that a show cause why you should not be, action should not be taken against you. Action you need not specify blacklisting or whatever, but it was not a, it doesn't even apparent, it is that it is some kind of an action action taken preceding some consequential, a panel action, whatever. That opportunity, perhaps written opportunity, which is required by law, is not the opportunity which you have given by this 2 email. That is what we tentatively think.
We have taken a pre-lawship since the several communications were given and they are being.
No, you have all the rights, Mr. Chaudhary.
Yes.
That you can blacklist him, you can debar him, whatever, but that has to be done in accordance with law. Law says that blacklisting, first case, Eurasian.
Yes.
It has adverse civil consequences. Raghunath Thakur used the same expression. Adverse civil consequences will require an opportunity. Proper Gurkha has expanded this. What is the nature of opportunity? How this notice is to be given, making him fully aware that on this aspect we elicit response from you.
No, here in this case, the difficulty was there, Lordship, because there was no response from the side of the company. Since
Now, if your notice was that we are seeking to
Yes.
take action against you,
probably to that extent, the clarification was not there to that extent.
That
The
only
fact
on
remains
that part.
Lordship, there was several
only on
communications
that.
from the side of
See,
the.
Mr. Chaudhary,
Yes, Lordship.
we may not interfere with an action where they have failed to respond, but we'll definitely see what is the nature of response you are seeking. Here, it seems that you sought a clarification that they did not respond. Let us.
And they failed to specify this with regard.
And
to the
this
anomalies.
last part, which you have said that amounts to admission, perhaps this is not an admission.
No, in their letter, Lordship, in the email communication.
Email 163,
Yes,
the petitioner has admitted you have that your anomalies are there. That doesn't appear to be an admission.
No,
You
subsequently,
please-
they have said that we are going to supply. all
No, no,
the
please
products.
read 163 again.
Lordship.
163 cannot term this to be admission of any. If you read it very carefully,
We have already mentioned in
See.
the catalog that we will provide 120 AH batteries of 16 numbers. However, as per your requirement, we will now be providing in the.
yes.
model. So
It's not,
subsequent-
that not, see, we have already mentioned in the catalog
Yes.
that we will provide so and so batteries of 16 numbers.
Yes.
However, as per your requirement, there can be various requirements.
No, the
See-
this requirement was there in the tender.
No, to have a penal consequence, there has to be some misconduct, some guilty mind, something to do with, which is legally not proper. Here it appears to be a
No,
mere
the
anomaly.
Why I may be wrong, Lordship, but this particular communication with regard to the fact that we are going to deliver this providing these particular products. That means at the time of when the tender was given to them as a L1. With regard to that-
These are inferences.
Exactly, Lordship.
Inferences we cannot act. We have to, we are mainly on the part, how was the opportunity granted to them? Was it adequate? Was it in terms of what is required by law? Only that part.
So we have taken that plea because the communications, our stand is that, Lordship, there were several communications from the side.
They
of the
did not
institute,
respond.
But they have not responded to those communications. And since from our this assessment of the entire aspect of the matter, it came to the notice of this respondents that there was some sort of anomalies on the part of the company on earlier occasions also. So taking note of all these aspects of the matter, we have very categorically specified here also, Lordship. The action on the part of the company is not tenable, absolutely untenable action. And in that view of the matter, so we have taken a stand that
Okay.
this entity of the particular.
Okay. That's all. Anything you'd like to add? Perhaps, nothing?
Well, only, well, that certificate has been given by them, my lord. Yes, to one example.
Please have your seat. A communication dated 27/10/2025 issued by the respondent NIT Silchar, whereby the petitioner has been banned, suspended from participating in all tenders issued by the NIT for a period of 2 years from the date of issue of the notice is the subject matter of challenge in this petition instituted under Article 226 of the Constitution of India. Full stop, para. The bereft of details, comma, the facts of the case as projected are that the petitioner is an MSME unit which deals with the business of manufacture of UPS, comma, batteries, backup system, etc. Full stop. The petitioner was entrusted to make supplies of their products to the NIT Silchar, and services was also provided. Full stop. It, however, appears that there was a complaint with regard to the supplies made, for which an email dated 16/9/2025 was issued. Full stop. The said email was followed by a reminder dated 18/9/2025, which was responded to by the petitioner. Full stop. Thereafter, the impugned order of ban / suspension dated 27/10/2025 has been issued. Full stop. Para. I have heard Sri G. N. Sahiwala, learned senior counsel assisted by Madam
Timor.
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 Timor. What is T?
Thanks.
Okay. Full name. I have also heard Sri S. P. Chaudhary, learned counsel representing the NIT Silchar, who has submitted that affidavit in opposition has also been filed. Para. The learned senior counsel has submitted that the impugned order of blacklisting dated 27/10/2025 having adverse civil consequences upon the petitioner is not preceded by a show cause notice. Full stop. He has also submitted that no proper opportunity was given, no opportunity was given to the petitioner before the impugned action was taken, and no hearing was also afforded. Full stop. Para. On merits, comma, the learned senior counsel has submitted that though it appears that some anomalies were found in the supplies made, comma, the emails issued to the petitioner do not even give a hint that there was any consequential action contemplated against the petitioner. Full stop. He has, on the other hand, relied upon a communication dated 18/11/2025 issued by the respondent authorities recording dissatisfaction on the services rendered by the petitioner, which includes the two numbers,
One number, madam.
which includes
One
number of the supplies mentioned in the email dated 16/9/2025. Full stop. The learned senior counsel has submitted that at no point of time there was any hint that such a penal consequence was contemplated and would be taken against the petitioner, which is impermissible in law without giving an opportunity as a opportunity. Full stop. Para. The learned senior counsel has relied upon the don't write it. To buttress his submissions, comma, the learned senior counsel has relied upon the following decisions, three decisions, Raghunath Thakur, Gorkha, number 3, daffodils, and no, Arvata, 4 decisions, SBI Rajesh, full stop, para. Towards the end of his submissions, the learned senior counsel has also taken, drawn the attention of this court to the affidavit in opposition filed by the respondent numbers 2 and 3, wherein the justification has been sought to be made, full stop. He has submitted that such justification would not meet the requirement of law as laid down by the catena of decisions relied upon by him. Full stop, para. Per contra, Sri Chaudhary, the learned counsel for the respondent number 2 and 3, has submitted that opportunities were indeed given to the petitioner before the impugned action was taken, full stop. He has submitted that admittedly no response was made against the email dated 16/9/2025, for which a reminder was issued on 18/9/2025, full stop. He has also submitted that from the communications exchanged, including the reply email dated 18/9/2025, it would appear that the petitioner had admitted the shortfall in the supplies, and therefore he submits that the impugned action is fully justified, full stop. He has submitted that the action has been taken bona fide and in the public interest, as the supplies made are in the form of essential service, which is required for the smooth functioning of the institute. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. The law on blacklisting is well settled. Full stop. The Honorable Supreme Court, in one of the landmark case of Eurasian equipments reported in 1975, 1 SCC 70, has laid down that an order of blacklisting having adverse civil consequences is essentially required to be preceded by an opportunity which conforms to the principles of natural justice. Full stop. The said principles have been consistently followed in the subsequent decisions by the Honorable Supreme Court, including the decisions relied upon by the learned senior counsel. Full stop. In fact, in the case of Gorkha Security Services, the scope has been expanded that the opportunity granted should be not only a formal opportunity, but one in which the party would have the full scope to explain the position. Full stop. In the instant case, this court has noticed that in the affidavit in opposition filed by the respondent numbers 2 and 3 on uh, 25/6/2026, a specific stand has been taken that the action has been taken taken in accordance with law. Full stop. In paragraph 14 of the said affidavit, it has been specifically averred that the action is complaint triggered comma, inverted comma, complaint triggered, comma, verification based, comma, preceded by retained opportunity, full stop, inverted close, full stop. While the first two aspects may be correct, comma, the opportunity which has been pleaded appears to be those which have been given via the email dated 16/9/2025 and the reminder email dated 18/9/2025, full stop. A cursory glance of both the emails would, however, bring this court to a conclusion that the contents of those cannot, by any stretch of imagination, be deemed to be an opportunity to show cause before any panel consequence action is taken, full stop. On the other hand, comma, the emails would reveal that a query was put to the petitioner as to whether they had complied with the minimum guarantee VAH as required in 2 GEM now orders, full stop. The submission made on behalf of the NIT that the petitioner has admitted the default is does not appear to be either factually correct or can be a ground to issue the impugned order, full stop. The response made by the petitioner via email dated 18/9/2025 cannot, in the considered opinion of this court, be construed to be an admission of any anomalies or misconduct in making the supplies, full stop. Further, comma, even if the same is construed to be some kind of admission, comma, it is clear that neither the email dated 16/9/2025 nor the reminder dated 18/9/2025 can be construed to be to be an opportunity before taking the impugned action of blacklisting, full stop. Para. In the conspectus of the aforesaid discussion, comma, this court is of the considered opinion that the conditions precedent before issuing an order of blacklisting has not been followed, more particularly on the aspect of giving a proper opportunity, including a personal hearing, which is mandated by law, full stop. In view of the above, comma, the impugned communication dated 27/10/2025 is interfered with and is accordingly set aside, full stop, full stop. The present action, however, would not stand on the way of the respondent authorities to take action, which, however, has to be strictly in accordance with law.
Liberty to the on authorities to take necessary action.
What we have stated on the last part. Should we want to repeat this? We have done it enough in
Much less.
Item to Mr. Dasgupta.
Mr. Kolita has some problem. He is in group number 10.
Mr. Sharma is there. What is the matter? Award?
No, not award. It is a strike was called by an union, and in consequence with that, liquidated damage was imposed.
Upon whom? The union?
Oh.
Under what is the foundation of the liquidated damage? On what basis?
Actually, what happened,
No, do you have a contract between the management, that they'll impose liquidated damage on the union.
But so far, section 19 of the Trade Union Act is concerned. That is very much clear.
Can you put the consequence on the union? He must have given liquidated damage to some contractor.
Yes.
But you cannot.
The union
You cannot.
actually, no,
Okay,
actually
we'll
it-
examine. We'll examine.
Union, and it was realized by the contractor. So let it be fixed on Tuesday.
Tuesday is okay. While
He is in court number 10.
Okay, while Sri A. Dasgupta, Learned Senior Counsel is present, an adjournment has been sought for on behalf of Sri A. Sharma.
K. Kolita,
Learned Counsel representing the Oil India Limited. Fourth subpara. In the interest of justice, matter is adjourned to be listed on Tuesday. You have the date. Yes, 2018.
My lord, first taking up, my lord,
Which one we take first?
3548.
Huh?
3548.
Second one will take up first.
Yes, ma'am.
Where is your colleague, Mr. Singh?
He has been there. My lord.
What is it?
My lord, this is regarding, my lord, the difference in the distance. Once the contract has been executed, they have reduced the distance, my lord. In the next
There are many
tender process.
decisions. What has
Yes,
happened?
yes.
No, Anup trade and all.
Lord, I have, in fact, on last occasion, I have given the judgment to your lordships, my lords. They are there on record. I said, my lord, that these are covered cases. My friend has wanted to some distinguish this. He wants to distinguish my first case with the second case, my lord. There, the facts are little different. There, what has happened? When I started the contract, it was there mentioned in the NIT. When Lord, first I executed that, I discovered that distance is less, distance is more. Then I submitted a representation. So that was during the continuation of that work. There, your lordship also held that they should increase. And
After verification.
Yes, after verification. That verification record is also there. In the first case, after this contract is over, then when they want to tender it for the next time, my lord, then they discover this distance. So once we have already completed, everything is been done, my lord, they cannot do it, my lord.
It is less, according to them.
According to them, it is less, but the contract stands executed. Lordships, I have, Lord,
But same route, same route.
Same route.
Same route if you are, how can you have both the
No, not same route.
Or not same route?
Not same route. Different contracts.
Different
contracts, different routes.
Context is the same, but the routes are different.
Yes, yes, yes.
One case they want to deduct from you.
In both cases.
Okay.
In one case, they don't give me relief. They say that we have measured it. It is less. So though you have executed, we will not give you.
You are asking for more in the first case, in one case. Because as per you, the distance is more.
Yes.
They have said that it is all prefixed.
They have also paid me part of that.
And the second case?
Second case, while executing, I come to know it's less. It's more. In the tender, it was less. So we have requested, they deployed the person, the distance is measured and it comes more. Now they take in the GRC different view.
Okay. What about the redressal committee?
Both, they have gone against me. In fact, similar matter has been disposed of by a lordship, not single judge, and then taken into appeal. The appeal has also been dismissed.
If it is covered, Mr. Singh, wait for a while. Sit for a while. You are in a hurry. 1 minute break.
Yes, yes, but this has been done.
What I want.
Hey, 1 minute is not over. 1 minute is not over.
1 minute is not over.
30 seconds still there. Rest for 30 seconds. Take your breaths.
Otherwise, it's too hot in outside, Malad.
It will be it will be very hot inside also after a while.
No, with my learned friend there, Malad.
Where are you seeking? Where are you seeking time in these matters?
No, Malad, what happened? We both have the different matter, Malad.
Okay.
For some
That
urgency.
is over.
Malad,
That is over.
Malad, I was in some other court, then again that came up, Malad. I sought for time being. Then, Malad, it was adjourned.
Very good. Conducive
missed-
for us to have these matters.
What I am submitting that this.
Now, first, let us have this one by one. Which one will you press?
3548. first.
On the aspect why it's not covered, Mr. Singh?
One judgment was delivered by your lordship, my lord. That is.
Anup.
It kept in abeyance, my lord.
Anup.
By the Anup trade, my lord.
Captain Abens. He says that the writ appeal was dismissed.
No, Malad, in other case, there is, I have.
And this matter, 2008 matter has been tagged with this matter because the petitioner cannot approbate and reprobate, my lord. In first item.
That is what we are hinting on, Mr. Dubey. He says that no, I'm not, the principle is the same. That is what he is saying.
In one case where the distance is lesser, he is claiming that no.
This has been put to mediation.
Yes.
Mediation.
That was put to mediation, but it was listed yesterday. The now new section council has appeared for the contractor. They have some time.
No, what happened in the mediation?
The mediation failed.
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 Who was the council?
Earlier, Mr. Senior Advocate James Sahewala, they are now new set of council has come.
Who's now new? Huh?
PN Goswami.
PN Goswami.
PN
वहाँ हुआ क्या देख तो यहाँ रखा है 3 जजमेंट था उसमें 3 जजमेंट
Mediation has failed.
Another matter is there regarding distance GB Chaudhary, my lord, arising out of writ appeal number 26 of 2023. Honorable Supreme Court has stated that the impending judgment will not be quoted as a precedent. I think which my learned friend is referring to writ appeal 26 of 2023.
So no, it may not be a precedent, but will definitely adjudicate on its own merits.
Yes, what I am submitting is that let's be educated on its merit of the case, both the cases.
Okay. Will not.
In one case, he is referring to that where the judgment, where the distance is lesser, he's saying that no, at the time of the NIT was floated, it was the distance was fixed, so he want to take advantage of that. In the other case, where the distance is more, now he's asking for the more B. So he cannot approve it and reprove it, either of the two.
That's why my learned friend has clubbed both this matter together, blood.
To build up this argument of approbation,
Yes,
reprobation,
yes, yes.
which he did not have earlier.
He had separately, I would say. Now this has been clubbed together.
Yes, you tell us which one should we take, what to do, what course of action we should adopt. Which one?
3548, my lord.
3548.
My lord.
Okay. Mr. Das, which matter of yours? 42. If this hearing takes place, others perhaps will not be possible. We can have another date. You can, court master will give another date. Okay, this will take time, at least 1 hour. Mr. Gogoi?
Item 19, some urgency, infrastructure project is in hold.
Who's on the other side?
Mr. S.K. Ghosh.
Huh?
Ghosh.
S.K.
Ghosh.
S.K. Ghosh? Or A.K. Ghosh? Or Sujit, yes. You call him then, if your matter is urgent, we can, because this hearing will take time.
Yes.
Yours is for what stage?
The project, affidavit has been exchanged. Our project is on hold, it's a foreign funded, that money will go away if you don't execute it.
Mr. Borthakur is there or what?
Loss. Your loss, I fix a date, your loss. 19. 18 your loss.
No, not 18. We are on this list. Others we can give a date. His matter is urgent. Huh? You have him. We'll try to have your matter. Others will not be possible unless it's very urgent. This is going to take time. If you get him now, we can try to finish off your matter, then touch your matter. How long will it take?
It will require some time because not that time. I have to convince my lords because there's an interim in operation. That interim was passed total in teeth of the specific relief act. Infrastructure project should not be touched.
NG has been explained later on.
My lords?
NG has been explained later on.
Yes,
It is only with regard to the amendment in the specific relief act. What is the subsequent decision where NG has been explained? Have we got or not?
After NG, there was another one.
No, there is a subsequent is that NG will not apply in all matters. It is only for the amendment 2H or something.
Yes, amendment was 28.
The only for that matter, the NG judgment had come. Subsequent decisions are there. Have we got the subsequent decision? Bring it. It's been explained. Since you have, it seems you are confronted with NG, specifically relief act, you can get the decision. It might probably will help you. Okay. Yes. We have 3548.
Yes, my lord. My lord, kindly come to page 39.
Of 3548, page 39.
Yes, my lord, in Annexure 2.
Mr. Ghosh. He says there is some urgency. This is also old matter, but this can wait for a while. We have that matter. Oh, after, okay. We will see the trend. If it's late, we will have a date. Let's wait for a while. Don't go away.
But can I make one prayer, Lord?
Yes.
Since Lordship is deciding on merit, Lord, but I was under the impression that it will be covered, Lord. I would also like to rely upon few judgments,
Now
Lord.
you bring those because if he is raising the objection,
My Lord.
we'll decide on merits, and there's a observation by the Honorable Supreme Court.
Yes, yes, because that's not in law.
We'll decide on my own merits. Okay. Yes, Mr. Gogoi.
Can this matter be taken up on 12?
When?
Well,
To 18 matter, we are not adjourning, Mr. Singh. 12th. Which month are you?
next week.
Adihol?
Actually, I have to travel to Arunachal now.
11th.
11th.
11th. Okay. 11th. 11th. Huh?
Both the matter.
Both. 11th.
Okay.
11th. For hearing organized admission area.
My lord, here in this case, my lord, actually matter has been settled by virtue of the alternative arrangement which has been made by the petitioner, my lord. What happened when the tower line has been, the survey has been done, in our absence, it has been done. They taken the land of the petitioner and keeping the government land in the side of the land of the petitioner. Then we filed appeal also that there is an alternative.
Now tell us the facts, what had happened. You are the APDCL.
No,
AGCL. Some lines have been towers have been constructed. Lines have been
constructed. They are proposed to construct tower line.
okay.
Kindly see the order passed on 27/4/2026.
Court order.
Yes.
Page, date?
27/4/2026.
27/4. There is no order of 27/4. Yes, 27 first order.
Yes, first order.
Please, yes. Please read which part.
Well, last part can you see, my lord?
Yes, please read.
That I will have to make a alternative arrangement to accommodate the persons who are affected if the line is taken away through government land. So alternative.
Which part?
Order to. Order to.
এইটো এটা লিখি দিবাচোন আইটেম নাম্বাৰ কোনটা আছিল FCI কেটা 3 and 4 on a joint
paragraph
request,
6
just on a joint request matters are adjourned to be listed for admission hearing on 11/8. Paragraph 6.
Paragraph 5.
Yes, 5.
It is further seen that the petitioner had placed before the concerned respondent authorities that instead of passing the said so-and-so line over the petitioner's land, the said transmission line may be passed through the government land when there are two families whom the petitioner would accommodate in his private land, in my land. It is the further case of the petitioner that in the meantime, on 22/2026, an office order was passed, thereby directing the petitioner to arrange a feasible route duly approved by the competent authority within a period of 90 days and failing to do
feasible route.
Feasible route.
And failing to do so, the respondent authorities would take effective steps.
Laying the
for laying the DC
line
transmission
over the land of the petitioner. So I have already made the these two affected family shifted in my land by constructing her house, my lord, of my own. That document is This is the old photograph, my lord. I have already constructed this house and they have shifted.
Yes, in that case, why don't you?
What has happened, we contracted two surveys, my lords, two study, technical experts, my lord. The route which is sailing, my lords, is the best route. We cannot bend it, my lords.
No, no. What about these observations by this court?
And government, kindly see the government affidavit, my lord. In the government affidavit, the route has been, after resurvey, my lord, kindly see the government affidavit file. There, the survey map has been annexed. It was 27.
Mr. Gogoi, there is no absolute embargo in your line. If the court has taken into consideration that there is an alternative possibility by going by government land, and those two families will have to be taken care of by the petitioner, which he contends to have done, then
This is slightly different. We conducted two surveys technically by the rules also, my lord, that route is the best route. You know, deviate from that route. Here, there is a compensation if anything happens to his land.
no, that is a different aspect, whether we agree with you. But we are only discussing because this court has applied mind on 27/4/2026 and has also made certain observations pursuant to which the petitioner has
Already.
contended that he has acted upon it.
Acted upon. And kindly
Why did consideration had come up?
Then, my lords, that
This is
same
the-
order, my lord, see, Miss K. Foucault was representing the AGCL.
Yes.
Our stand was not clear that time. Our stand was fixed for instructions. Paragraph 8 of the same.
President, the owner of the proposed to lay down census.
So our presence was recorded, nothing was.
As placed before the.
My lord, why this order has been passed, my lord? Kindly see the pace.
See, that is not a direction as such, Mr.
Not a direction.
Mr. Ghosh. District admin shall also place their stand by filing their affidavit as to whether any other feasible route through the government land is possible.
Yes, that has been given.
And whether the district would have any objection in permitting the petitioner to accommodate. That is only one of the possibilities.
Possibility. Now kindly see the order passed by the AGCL, page 26, my lord.
26.
26.
No, 26 was, this order was before this court. Court had passed
Yes.
this order in this petition on 27.
Yes, last part of this order, kindly see.
Yes.
27, page 27, last part of the order.
Yes.
If, Lordship got it, last
Yes.
para. If Sri Avinash Das,
You are Avinash Das.
yes, fail to arrange such technical feasible route duly approved by the competent authority concerned district administration.
Yes, such technically feasible, not
Yes.
only road, technically feasible.
Feasible. Now kindly see, then accordingly, the fresh survey has been made on 21/3/2026.
When 21?
21/3/2026.
Fresh survey.
Yes. And this survey report has been annexed at running page 66. Can you see?
66.
66. Yes. '66.
Report, it will be, I think,
Sketch map.
sketch map. 70, I think, 70. 70.
This new proposed route is proposed line. Lordship got it. And this two family has been demarcated. And this two family already I have shifted from.
No, that is not, that may not be the end of the matter. It depends on what they say. That was one of the possibilities to explore.
Possibilities, yes.
You said that I'm ready to, but that will not bring the matter to an end. Still, then they would like to go by the best possible best. See, they are the best judge how the line will go, where the stringing will be done.
No, this survey has been made at the instance of all the parties, my lord. It is not that in our absence, it is all the parties are.
Doesn't
present.
matter. What is this? Please explain it to us.
My lord.
This sketch map, please explain. What is this sketch map?
Sketch map. This is the old route is the lower one, my lord.
Which one?
Lower portion.
Lower portion.
Yes. This post number 3 and post number 4 falls in my
Where are the post? Where do you get post numbers?
That is not mentioned here. It is from 5. Kindly see 5. There is 5.
5/0.
5/0.
It's a post.
Yes.
Okay.
Then in the below.
Yes.
This post has not been not yet been started, not constructed.
Yes. Yes.
It is proposed. This is over my land. And next one in right side. This is also my land.
Okay.
Now the proposed, my lord, kindly see 3. 3 has been constructed.
Yes.
From 3, they are proposing, the new proposing is 4.
Which will exclude your property.
No, this exclude, yes, this exclude my property.
If you will be satisfied if it goes straight.
Yes.
Not through your.
Yes. And this is the government land, not my land also. And by this land, the 2 persons are occupying the government land, that I am ready to accommodate them in my patta land.
Mr. Gogoi,
I have already given.
This does not appear to be wholly unreasonable. See, in fact, this line becomes straighter. The earlier line was slightly in an elongated way, in a curve. Now it becomes straight.
My lord, with due respect, my lord, we are not aware of this kind of survey. In lordship, there are no minutes, no signature, no representative from our side, my lord.
My lord, this was annexed by me also in my writ petition also.
Thereafter, my lord, we conducted 2 surveys. I have filed affidavit in opposition, my lord. See, that technically feasible, most feasible route is that route, my lord, earlier. Even the.
No, this letter is by whom? The additional deputy commissioner.
Yes.
No, not written to the ADC. Who? By who is this Anil Chandra Das? Who is no, Avinash. Avinash is you.
Avinash is I am the Avinash.
No, who has written? Who has made this? This survey is prepared by whom?
Survey is prepared by the government between all the parties.
No, where do you get it?
This I will get, my lord. Kindly see my writ petition, my lord.
These 3 papers, these are your papers, Mr. Host. Huh? That's why but this additional evidence.
My lord, may I clarify, my lord?
Well, just a minute. The opponent has already filed affidavit opposition. In paragraph 4 of the affidavit opposition, stated as per letter received from the petitioner, alternative route so and so was proposed after a joint verification but inadvertently letter mentioned in this paragraph could not be annexed. It is we are only including this.
Within paragraph, though it was mentioned, it was in fact not annexed later. So that's why by this, I have brought a record the letter by the and the scat by the authorities. So that's why that letter was not.
That's map you have prepared.
No, my lord, may I clarify? Paragraph 10 of my writ petition, my lord. With respect to this case map, kindly see that your petitioner beg to states that thereafter respondent number 6 resurvey the proposed line in presence of the petitioner along with
who is respondent number 6? ADC.
along with respondent number 5. And accordingly, respondent number 6 prepared a sketch map, and after going through the new proposed line, two families who were
Mr.
occupying. the
Gogoi,
com-
have you taken instructions on this?
This is my paragraph, specific paragraph.
A surprise for me. Otherwise, my lord.
You take the instructions. See, we are willing to agree with you. You are the best judge. One person's difficulty will not come in the way of a transmission line. That is of much more importance. But at the same time, if a wire media is found to try to be sorted out by this court,
Yes.
in which there has been some progress also, which is also supported by Madam's affidavit, you just need to take instructions on this.
I'll take.
You come back on Monday.
My lord.
Monday. Monday will be for disposal, no?
My lord.
We will not adjourn this matter.
It is not a surprise. I have specifically stated this with respect to this.
Okay, heard 3 SK Ghus, learned counsel for the petitioner, as well as 3 D Gogoi, learned standing counsel AGCL,
AGC.
full stop, as well as Nakoba. Heard SK Ghus, full stop. Also heard 3 D Gogoi, learned standing counsel AGCL, as well as Miss Udas, learned state counsel, full stop. Para. In the additional affidavit filed by the state, comma, there is there is an enclosure of a letter written by the petitioner along with what do you call this?
Sketch map.
Sketch map. Full stop. Sri Gogoi, the learned counsel for the AGCL, however, submits that he is not aware of the aforesaid development and would accordingly and would take instructions on this. Full stop. As urgency has been expressed, comma, though the matter is adjourned, comma, the same is directed to be listed on Monday next.
Sketch is also part of the writ petition. Letter is annexed.
Yes, I have an annexure for. Much.
My lord, I am sitting here for item number 5, lordship. Though here is not any interim order, but the matter relates to the construction of national highway and disbursement of the compensation, lordship. And long before NHIDCL respondent 1 and 2 have filed affidavit, lordship. But Kala has taken number of times, they have taken adjournments, lordship. They want to file one additional affidavit, but till today, they have not filed, lordship.
If you are willing, we can have this for disposal.
Lordship may kindly dispose the matter on the basis of our affidavit, lordship.
Yes, madam.
Actually, we have to file an additional. We were waiting on the official report on the last occasion, that is on 2/26.
From 2 to sufficient time has gone, madam.
Yes, but waiting on the official report and we have finally received that.
You have received it.
It has been found out that the ARO and other official signatures were forged. So we want to file an additional bringing that on record. So we will find.
But we'll file it within a week.
By Monday.
Okay. Okay.
May kindly allow the-
Okay. Heard. Miss, your Yanthan.
No, mine.
Heard Miss Yanthan, learned counsel for the petitioner. Also heard MS VL Singh, learned standing counsel NHIDCL, as well as Miss learned counsel appearing on instruction of Sri J. Chutia, learned standing counsel as KAAC. Full stop. Miss Udas, learned state counsel, is also present. Para. Miss so-and-so learned counsel representing the KAAC has, however, informed that recently the FSL report has been received, as per which serious anomalies have been found in the report. Full stop. C has submitted that the affidavit in this regard would be filed shortly and accordingly placed for 7 days time. Full stop. Para. As urgency is involved, comma, though the matter is adjourned, comma, the same is directed to be listed on, we'll have it on 14th, is it okay? 14th, next Friday. The 18th will be 18th Tuesday next. Get more than okay, Tuesday on 18th.